If you have enough copies to the other members. Let me know when you're ready, Christina. Please.
All right, all set.
Okay, thank you. Those of you who are watching online, welcome to the Municipal and County Government Committee here March 1st, 2021. As chair, my name is Tom Dolan. As chair of the House Municipal and County Government Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to the executive order 2020-04, that this public body is authorized to be electronically. This is a committee meeting. Please note there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice of this meeting complies with House rules and RSA 91A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. Christina Dyer, committee researcher, will be on the staff assisting us. Please note that all votes taken during this meeting will be done by roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there's anybody in the room with you during this meeting if you're on Zoom, which is required under the right to know law. Mr. Clerk.
Representative Dolan.
Here.
Representative Piemonte.
Representative Piemonte is attending another meeting. He will join us in about 45 minutes.
Clerk is here. Representative Tripp.
Present.
Representative Guthrie.
Here.
Representative Lascelles.
Here.
Representative McBride.
Here.
Representative Melvin.
Here.
Can you, interrupt?
Talking to the phone.
We need, if you're on Zoom, we need you to
My phone.
not only identify that you're here, but if you're alone, where you are. So, Representative McBride, could you do that again? You have to unmute. I'm sorry. Representative McBride, just need you to know if you're alone in the room you're at.
Yeah, I'm in the lab at work.
Okay.
Okay, Representative Melvin.
Here.
I show Representative Veer absent excused. Representative Pimentel.
Present in a room by myself.
Thank you. Representative Power.
Here, I'm at my home in Brookline in my office alone. However, there's another family member elsewhere in the house.
Representative Porter.
I'm here in Hillsborough. I'm alone in the room, but my husband and cats are in the house.
Representative Trelevin.
Good morning, Mr. Clerk. I am here in Dover, New Hampshire, by myself downstairs, and the cat's taking a nap upstairs.
Representative Gilman is excused absent. Representative Majority.
Thank you. I am here alone in my office in Northampton.
Representative Davis.
My apologies. I am present. I am here in my home in West Lebanon, and I am alone.
Thank you. Representative Megapudi.
Namaste. I am here in my home in Nashua. I'm alone. My husband will be coming in around 2 p.m.
Representative Van.
I am at my house in Peterborough. My husband is in the other room, and there are dogs.
Representative Clee.
I am here alone in my family room in Nashua. My husband is in the house, as are my two greyhounds who noses will appear every now and again. Thank you.
Thank you.
And I can hear the
Representative Gallagher.
I'm here in my apartment in Concord and I'm alone.
Okay, and Representative Lang.
Representative Lang has not joined us yet. He will join us soon.
Attendance is completed, Mr. Chairman.
Okay, thank you. All right, we're going to start our testimony today on House Bill 431, which is relative to the responsibilities of an elected animal control officer. We have with us in the LOB sponsor of the bill, and the floor is yours.
Thank you, Mr. Chairman. Thank you, members of the committee. For the record, my name is Representative Scott Wallace, Rockingham County, District 12, the town of Danville. House Bill 431 is a house cleaning measure that will seek to have the same accountability and oversight of the road agent position in any town that has an elected animal control officer position. Presently, the town of Danville has an elected ACO, and when the warrant article passed, the warrant article was rather short and did not have any oversight or accountability provisions in said warrant article. So this particular bill would just provide for oversight and accountability of the position. And it's as simple as that. This position has been back and forth between an appointed position by the Board of Selectmen, subsequently made an elected position, then back to an appointed position, and now currently an elected position. So over the past decade, there's been some gaps in coverage and services needed in these particular areas. Hence this particular bill to make things a little more streamlined and get the citizens in Danville and the animals in Danville a little bit better and streamlined care with proper oversight and accountability. And it's as simple as that. And I'd be happy to take any questions at this point in time.
Anybody have questions for Representative Wallace?
Mr. Chair, I do.
Yes, Representative Manchester, please go ahead.
Thank you. Thank you for taking my question. Representative Wallace, is this position an elected position across the state or only specific to some counties?
Thank you for the question, Representative. It's my understanding that Danville may be the only town with an elected ACO in the state, although I'm not 100% certain of that. But that being said, any elected position in any town needs to have oversight and accountability, and especially for background checks to ensure that we have the appropriate people in these positions. This is not about the person that holds the holds a position presently. This is about anybody that holds any elected position in any municipality in the state.
Any other questions?
Yes,
Representative Porter has her hand up, Mr. Chair.
Yes, please go ahead.
thank you, Mr. Chair, and thank you for taking my question. The town clerk in Hillsborough is elected. Would that mean that the select board has authority over her? Can you answer that question for me? Can the select board discipline the town clerk to your knowledge?
That's an excellent question. I'm not sure of that, but I suspect that there is oversight and accountability for all positions. In the event of any maladministration or misconduct, there is a method of redress in the town, I'm certain.
Thank you.
Representative Pimentel?
Thank you, Mr. Chairman. So if I got this correct, this is the only town that has an elected animal control officer right now. Is that correct?
That appears to be the case, Representative.
And a follow-up, Mr. Chairman?
Yes, please, go ahead.
So my guess is that it's the prerogative of the town itself to decide to have it either elected or a non-elected position. Is that correct?
That is correct. And typically when elected officials are put into a position, there are, if that's done by a warrant article, the details of the authority and oversight are incorporated into said warrant article, which didn't happen, which was probably just an oversight in this case. I don't believe there was any nefarious or malicious intent. That oversight and accountability wasn't written into the warrant article. And that's why this bill is coming forward, just because it's an administrative challenge for the town presently, as you can imagine. The position was an appointed position as recently as 2 years ago and as long as 10 years ago. And it's gone back and forth a couple of times in the interim.
Mr. Chairman, could I have a third follow-up? I'm sorry.
Yes, go ahead.
Thank you. So I don't want to sound, so if they can change it from elected to non-elected and back and forth, why are we as a legislature getting involved in the town's issues?
Thank you for the question. The reason is this has gone back and forth so many times. We don't have, when the people of the town and the animals in the town are not getting the level of service that they should be getting. Okay, so we're looking to tighten that up. And absent another warrant article, the only method by which to do this is to make it a parallel position, just like all other elected positions, like the road agent, which reports to the Board of Selectmen. Every position, including ours, we do have oversight and accountability in some manner. And currently, the elected ACO also sits on the Board of Selectmen, which would be the oversight and governing body. So what's the problem?
Okay, before I go to the next question, I just wanted to report, we've had a lot of folks sign in on this bill. We've had 156 people sign in to support the bill, and 47 signed in to oppose the bill. Next, I'd like to recognize Mr. Graves from the NHMA who opposes the bill.
Hello, Mr. Chair. This is Nate Graves, the New Hampshire Municipal Association. Can you hear me all right?
Yes, go right ahead.
Thank you. So we are taking no position on the bill. We did have a suggestion, which was that the committee amend the bill to move the reference from chapter 42 to chapter 41. And the reason for that is the sponsor places this bill in chapter 42, which is the oath taken by town officers chapter. And it seemed more appropriate that it would be chapter 41, which is the chapter which basically lists all of the different positions in the town and whether they're elected, appointed, or whether the town has an option for that.
Any questions from Mr. Graves? Seeing that, I will recognize Representative Davis.
Mr. Chair, I don't believe I had my hand up raised.
Okay, I thought I saw a note from the. All right, next we'll go to Representative Blasek, who supports the bill. Okay, Representative Blasek's not available. Let's go to Representative Horrigan, who opposes the bill.
Mr. Chair, I don't see either representative listed here. The two representatives on the sheet that I have, excuse me, the two people on the sheet, Sheila Johansson and Stacy Ober, are both on the list, but I don't see the two people you named.
Do we see Karen Testerman?
Testerman?
Yeah,
I do not.
and Nancy Bond,
I do not.
and lastly, Timothy McNamara.
I do not.
All right, let's go to,
I think they're to testify on other bills. If you look at the top,
Yeah.
yes, you're right, I'm sorry.
431 only has two.
Yes, you're right, thank you. Let me ask, I'd like to ask a couple questions. Who would provide the oversight and accountability, Representative Wallace? The Board of Selectmen, just like we currently do with road agents?
That is correct.
And any other questions from the committee?
Mr. Chairman,
Yes.
this way.
Oh, yes, I'm sorry, Representative Guthrie.
Thank you. I'm a selectman in an adjoining town of Hampstead and a selectman there also. And it seems to me that this bill does what we would like to see done in, and is done in most every town. But it does not, I think we've been misled somewhat that this position is still elected, will continue to be elected unless the town changes from elected to an appointed. My understanding is that this bill does nothing other than make sure that there is some accountability within the town by the selectmen for anybody that's sitting in this position that's elected. Is that correct?
That is 100%.
So it doesn't take the position out of the elected category and put it in appointed.
That is correct.
All right, thank you.
Thank you. I have one last question from the chair to Representative Wallace. Why is this needed now after what you've been through in the community?
Thank you for the question, Mr. Chairman. This is needed now because the town electorate voted to make the animal control officer position an elected position, but the warrant article doing so did not specify the ways and means by which the position would be governed. This bill simply sets forth a manner by which the position shall be administered.
Thank you. Any final questions for Representative Wallace? All right, seeing none, I'm going to close the hearing.
Oh, Mr. Chair, I'm sorry. There are two people who still wish to speak on this bill who did sign up. Sheila Johansson and Stacy Ober.
All right, let's recognize Ms. Johansson, who's speaking in opposition to the bill.
Okay, and I have just, I believe, just a lot. There we go. Okay.
Are you all set?
Yes.
Good morning. Thank you for letting me speak. First of all, Mr. Wallace, citizens petitions can be done by any citizen as long as you have 25 signatures that are registered voters. I want to let you know, in case you remind you, that yes, in fact, the original citizens petition, and I'll read it to you, state, it was to direct the Board of Selectmen and the Chief of Police regarding animal control position. It read, with the signatures on there, to see if the town will vote to direct the Board of Selectmen and the Chief of Police to employ the elected animal control officer position as a paid employee of the town of Danville, and to not delegate or contract the animal control officer position. Said animal control officer duties shall be those as detailed in the 2011 animal control officer description. Said animal control officer position shall also be initially compensated at no less than 2011 funding amount. The animal control officer position is an elected, not appointed position, and this vote shall take effect immediately following March 2014. as all procedures go, a town deliberative session shortened that petition, as they can do. And that is why you didn't see what you saw. The town deliberative session cut down what was the signatures for, and it came to be voted on as to see if the town will vote to require that the animal control officer position be reinstated and be elected yearly as permitted by the New Hampshire RSA 41:2, so that the animal control officer will be on the town ballot in March 2013. I will also let the committee know that a lot of these citizens petitions, as they were voted on, were changed at deliberative session. And there was at one point, trying to get my things here.
While Ms. Johansson is collecting her thoughts, I asked the committee to consider her testimony now is not for the purpose of questioning Representative Wallace, but it's to provide testimony
Correct.
to oppose the bill. Please continue.
Another one that was done, that was voted on, and it was also shortened. And I'll read this one as well. To see if the town will vote to require and direct the Board of Selectmen and Chief of Police that the animal control officer position be reinstated and be elected yearly pursuant to the New Hampshire 41:2. The elected animal control position shall employ the elected animal control officer position as paid employee of the town of Danville, not to delegate or contract the animal control position. Said animal control officer's duties, job description, and standard operating procedures shall be those detailed in the Rockingham Superior Court, March 5th, 2015, final order of motion of summary judgment, permanent court injunction decision, Sheila Johansson versus Town of Danville, number 218-214-CV-00442. The animal control officer position is elected, not appointed position. Said animal control officer position shall be initially compensated at no less than 2017 budget amount. This vote takes place immediately following the March 2018 position. That also was cut down to a short 1 or 2 lines when it was passed. And I have something written out that he kind of threw me off when he was talking about what he talked about.
Mr. Johansson, do you have what you're speaking to? Do you have that in writing?
I do.
Can you make sure that if you haven't already, if you could forward it to the committee?
I can. I can do that. Now let me go back to what I should have started with.
And before you continue, I want to let the record show that Representative Lang has joined us as of 9:30. Thank you. Please continue.
Okay. So my name is Sheila Johansson, and I've been an animal control officer for 17 years in the town now and in the town of Danville, and elected animal control officer since 2015. What does an animal control officer do? The animal control officer enforces state laws and town ordinances pertaining to domestic animals and provides education and information for mitigating wildlife issues. Animal control is dedicated to serving the community as it relates to both humans and animals. There are approximately 85 towns in New Hampshire that have animal control officers. Most are appointed to the positions and are not police officers. I am the only one that I'm aware of that has an elected animal control officer, which is in Danville. House Bill 431 has nothing to do with its title. This bill is set up or so-called amended to disenfranchise the voters. From 2004 to 2011, the Danville ACO was an appointed position. In April of 2011, I was not reappointed for the position. A citizen's petition was put forth. It was voted on, and it was to see if the town would vote to require the animal control officer position to be reinstated and elected yearly as permitted by the New Hampshire RSA 41:2, so that the animal control officer will be on the town ballot for March 2013. This, and we are, I don't know if you realize what the optional officers for 41:2 are, but that reads, in addition to the officers which towns are hereinafter required to elect at an annual meeting, any town may choose one or more collectors of taxes, agents, overseers of public welfare, constables, police chiefs, and other officers, and every other officer who may be directed by law to be chosen, and such other officers as it may judge necessary for managing its affairs, who shall perform the duties prescribed by law. Constables, police chiefs, and police officers shall be elected pursuant to provisions of 41:47. When the Danville Police Department and the Board of Selectmen chose to not, so that petition passed. When the Danville PD and Board of Selectmen chose not to abide by the town's voters, another citizen's petition of more than 50 registered voters was put forth again. And on March 2014, I ran for the elected animal control officer position. Danville Police Officer Cooper also ran for the position, and I received 394 votes, and Officer Cooper received 194. The Board of Selectmen also placed a warrant article to dissolve the elected animal control officer position, which was defeated. Again, the Board of Selectmen and the Chief of Police, Wade Parsons, refused to allow me to do the elected job. I then filed a lawsuit against the town on behalf of the town voters, of which we won. And I say we, as it was the town voters that won. On March 5th, 2015, the case number 2014-CV00442, Sheila Johansson versus the town of Danville, is when the final order was issued. Through this court order, an elected animal control officer job description and an elected animal control officer standard operating procedure was accomplished and developed through both sides' legal counsels, myself, the Board of Selectmen, and Chief Wade Parsons. Since 2015, there have been citizens petitions placed on the ballot to dissolve by a few residents. In 2017, it did pass to dissolve by 24 votes, and the police department did the job for 1 year. The following year, it was reinstated as elected again by a citizens petition, where it still remains elected, and their attempts to dissolve continue to be defeated. While the voters continue to support their elected animal control officer position, they also continue to support them so that the position is paid without battles from the Board of Selectmen each year for the budget. And Article 2020-17 was about the animal control officer compensation. And that goal was, on the warrant article, was to ensure compensation for an animal control officer and to include the compensation of the animal control officer position through the operating budget process in the future. Danville is the only town in New Hampshire that I'm aware of that has an elected animal control officer. Danville voters know what they want. This bill is nothing but an attempt to take away the voters' choice. This is clearly a town issue, not a statewide issue. It's an ongoing battle of power and small town politics by a few people. Representative Wallace, clearly living in this town, is aware and is just trying to backdoor our right to vote and choose. Since the voters have clearly spoken each time they have tried to dissolve the elected animal control position, the elected position is elected each year by the voters as per the New Hampshire RSA 41:2 optional officers.
Ms. Johansson?
I just got one more final thing.
Sorry, I just would ask you to be careful with your choice of words about elected representatives.
Okay. I am disappointed. Sorry, that Representative Wallace knowing full well the history of the town that he lives in, would try to disenfranchise the voters. This was more about trying to disenfranchise the voters of Danville's People's Choices and trying to invalidate our votes because we turned out in large numbers for these elections. And to tell us that our votes don't count and that they don't matter is another form of voter suppression.
Mr. Hanson, again,
Okay.
I would ask you to not try to assign motive to the representatives, just the facts, please.
Okay. Daniel Webster, I have a quote from Daniel Webster's precursor where he says, "It is, sir, the people's government, made for the people, made by the people, and answerable to the people. The people of the United States have declared that this Constitution shall be supreme law." And I asked the committee not to move this bill forward. One more thing while I was reading this. It was brought forth that the road agent isn't elected and the selectmen have choice. That's by law. Tax collectors, town clerks, those positions, road agent, those positions are by statute, by RSA. They do have things that the selectmen cannot oversee. I might add that just as the chief of police, he's elected. We do not have, selectmen do not have oversee his position either. So not every position, because they're elected, is overseen by the selectmen. As your positions, you report to the voters. The voters are what put you in the position. I think that I don't know if I can answer any more questions, but I would hope that that you people would understand that this is it has nothing. It's taken away the voters' choice. And again, citizens petitions can be changed, as you know, at a deliberative session.
Okay, thank you for your testimony. Is there anybody on the committee that has a question for Mr. Hanson?
Mr. Chair, oh, I'm sorry.
Yes, Representative Guthrie.
Yes, thank you for coming and giving your testimony. I don't know if you recall, I asked a previous question or asked to be clarified that this is not taking away the rights of the voters of the town. It'll still be an elected position. We would not be presumptuous enough to take that away. My question to you is, do you feel that there should be any oversight at all to your position, and why would you think one way or the other?
So it would be taking away the rights of the voters. You'd be taking away the right of the voters to vote for who they would like to be in that position.
I'm sorry, I must have not have been clear. If I could, Mr. Chairman, this bill does not do anything about whether it's an elected or appointed position. This bill would continue the elected position, and the people in Danville would have an opportunity to vote for whomever they wish. This is a question of whether or not that position should have oversight. And my question is to you is, do you think there should be any oversight for this position? And if not, why not?
It would be taking away the voters' rights who they put in there, because you have a board of selectmen could and have, that's the reason why it became elected, could remove somebody from that position and put whoever they want in the position. That would take away the voters' choice.
Thank you for your answer.
All right, we have a question from Representative Treleaven.
Thank you, Mr. Chair. My question is for Representative Wallace. Thanks for coming in and testifying today. I'm just wondering, I'm not really sure why this bill is being put forward right now. Can you give me a little insight into that, please?
Thank you, Representative. Thank you for the question. I will say asked and answered. We did, that question was asked earlier. I'll repeat my answer. Why?
I'm sorry. I'm so sorry. I must have missed it, but thank you for repeating.
Yes, you're entirely welcome, Representative. Why is this needed now? Because the town electorate voted to make the animal control officer position an elected position, but the warrant article doing so did not specify the ways and means by which the position would be governed. This bill simply sets forth a manner by which the position shall be administered.
Thank you.
And next we have Representative Davis has a question.
Thank you, Mr. Chair. This is a question also for Representative Wallace, and thank you for taking my question, Representative. I have kind of a three-part question, and it speaks to structure as opposed to the specific issues involved with this particular bill. And one is that, as Nate Grays pointed out earlier, the section, the RSA that this bill is proposed to amend has to do with taking oaths of office. And if this bill were to pass, the animal control officer would be the only officer required to take an oath that has this kind of a delineation of responsibilities and consequences for responsibilities. So my question is, why in this particular RSA and not in another? And then my other question has to do with the terms of selectmen in this town versus the terms of the animal control officer. Do they always coincide, or can they be different? And the reason I ask the question is if a particular board of selectmen has priorities and strategies in mind for a particular animal control officer, and their terms do not coincide, then does a new board of selectmen have the authority to impose new priorities and strategies for that officer?
Thank you for the question, Representative. Let me address the first one first, of course. When this was brought forward, I was thinking about this from an existing position standpoint, so that's why I focused on the RSA 42:9. But this is not my forte, the municipal county area. That's where you folks come in. And if it makes more sense to amend this to have the governing statute be 41:2, I'm certainly on board with that. Would be happy to make the amendment. To the second question, the warrant article has the ACO be elected annually. Our board of select members have different tenures. And if there is an issue or a particular matter that the board of selectmen wishes to govern, well, I don't know that that's an issue presently because our current animal control officer holds two positions in town, one as ACO and also a member of the board of selectmen. So I don't see what the problem would be unless there's a conflict of one supervising oneself. But given that set of circumstances, I don't think there should be a pushback from the current ACO. She would be, in fact, have a vote in her own supervision and oversight, would she not?
No.
Okay, next we're going to move on to Representative Gallagher has a question.
Yes, so my question's for Ms. Johansson. I'm wondering why it is precisely that Danville is the only town that has an elected animal control officer in New Hampshire. What is it about Danville that causes it to have issues with animal control that require it to hold elections to choose between people for this position, when other towns don't seem to feel that need?
Can you hear me?
Yeah, go ahead.
Okay. this position was created because of small town politics, starting back in 2011. That's how the position got created. I can't say it any other way. It is small town politics within Danville. I don't believe honestly, the money that this pays, nobody would, unless you were really passionate about something, most people would just walk away from the position and just, and whether it's appointed, and just leave it alone and go on. I'm very passionate. I've lived in this town over 33 years. Yes, currently I'm a selectman. And honestly, I became a selectman 6 years ago because of this. I've been on different boards of the town. I've been elected onto the budget committee. I love the town I live in.
No one's question.
Okay, Representative Davis, do you have your hand up, or is that an old invitation?
It looks like Representative has left the room for a moment.
I do not have my hand up. I just forgot to lower it. Sorry.
Okay, Representative Maggiore, do we have Stacy Ober on the line?
We did. Yes, we do.
Okay.
And
Stacy is the last speaker. She's going to speak in support of the bill.
Good morning, Chairman Dolan, members of the Municipal and County Government Committee. My name is Stacy Ober. I am the legislative analyst and community outreach in New England for the American Kennel Club. And American Kennel Club is a nonprofit. We've been around for 135 years, and we're recognized as an expert in canine health, training, breeding, and responsible dog ownership. We have 22 nonprofit dog clubs in New Hampshire. And when we saw this bill, we understood that the provisions would apply to only one animal control officer in the state. And I did reach out to the bill sponsor last week. I know you all had a very busy week last week. So you do have a copy of my written testimony. I was looking at this from the standpoint of giving you a couple of examples where we believe there would be value in providing some consistency around oversight and supervision for animal control officers. And our reference was to RSA 466, Section 1C, which, as everyone has acknowledged, provides great deal of discretion to the New Hampshire towns as to how they will provide these animal control services. In that language, you'll see it can be either an elected, appointed, hired, or subcontracted position. And so the testimony we submitted was really in the spirit of saying we support oversight and to please look at this section of the law so that there would be uniformity irrespective of what capacity the animal control officer had been employed or engaged.
Okay, thank you. Is there any questions from Ms. Ober? Seeing none, I'm going to end the hearing.
Mr. Chairman?
Yes.
There are at least one more individual who wish to speak. Whether or not you've seen them, I know that Chief Parsons does have his hand up. He just sent me a text to that effect.
Okay, Chief Parsons, are you on the line?
Representative Wallace, can you just tell me Chief Parsons' first name?
Wade, W-A-D-E.
Is he calling in, or do you know if he's zooming in?
I believe he's called in, or he just sent me another text. Can you hear me? He has his hand up, so he must be zoomed in, I imagine.
The hand up is Cody Belanger and Justine Merced. Those are the two hands up.
Okay, well, Justine is the lieutenant in town.
Oh, there you go. So maybe it's through Justine.
Could be.
I will hit allow to talk and we'll try that. Okay, thank you.
Thank you.
All right, Justine, the floor is yours. Go right ahead.
Hi, this is Justine Merced. Are you able to hear me now?
Yes, go right ahead.
Hi, thank you. So again, I am the lieutenant in the town of Danville, New Hampshire, and I do support this bill. And the reason being is, as far as I know, we are the only town in the state of New Hampshire that deals with an elected animal control officer. I've been listening along the way here, and I do just want to stress again, we're not looking to change anything about this position being elected. I care a lot about these residents in town as well, and it is really important to me that these residents have someone to rely on to hold this position accountable. I can tell you, in my position, we receive animal control calls at the PD that we have to forward to our Rockingham County Sheriff's Department, who handles dispatching. We also receive complaints about our animal control officer. We are not able to do anything about those types of complaints when we get them, because the animal control position is not part of the police department as it is in so many other towns in the state of New Hampshire. So when these complaints come our way, we direct them to the Board of Selectmen, quite frankly, because we don't know where else to send them. I've been present for some of these complaints that go before the Board of Selectmen, and even there, they pretty much die because, you know, these residents are told that they can't do anything about it. So it's not a matter of taking away what the voters want in the sense of who they want for their elected animal control officer. I'm just looking for some type of support that says, should this animal control officer not do what the town has voted them to do, that someone's going to be there to support them to say, okay, we're going to remove this person or whatever, take appropriate action against this person. So we're not looking to get into any type of personal politics or whatever was insinuated earlier today. It's just a matter of holding this position responsible, just as with our road agent. I mean, our town dealt with the same thing with our road agent, and our current ACO, who's on that selectman, was in support of oversight for that position. So I find it kind of odd that there's a picking and choosing of what positions that are elected get oversight. And just to touch upon the chief of police, that is an elected position as well. However, all officers in the state of New Hampshire are held accountable by Police Standards and Training Council. So my police chief is not able to just do whatever he wants, and you know, he's still held accountable. When calls don't get answered by the animal control officer, there's nobody to do anything about that. When calls aren't handled appropriately, there's no one to be able to do anything about that. And it's very frustrating for our police department to hear that our residents are so unhappy at times, and we can't do anything about it, because people think that this position falls under the police department. And I just want to be clear that it does not. This position is separate. This animal control position is a different department than the police department in the town of Danville. And I know that it seems, you know, this is only one town in all of the state, but it is the only town. And I can tell you that we are heavily affected by this. This position is not required to hold any type of police certification. Of course, they're able to enforce some violation level offenses. They're not allowed to go as far for misdemeanors to prosecute these things. And I will tell you, the person that is holding this position right now, Sheila Johansson, I know personally, I don't trust her to be part of my criminal investigations because of history that she has shown herself.
Let me say that I think that last comment may be inappropriate, so I would ask you to just talk facts and not impugn the motives.
Okay, and I apologize, but again, that's really where we stand as a police department as far as looking for someone to do something, because we can't do anything to hold this position accountable. And it's frustrating. We're hearing it from our people of the town. So I respect their vote. I respect who they choose. It's just a matter of being able to hold this position accountable when things aren't being done the right way.
Thank you. Let the record show that Representative Piemonte has just rejoined the committee at 9:58. So we have a next question from Representative Cleve.
Thank you, Mr. Chairman. I'm not sure who to pose this question to, if I would be posing it to Ms. Mercedes or to Representative Wallace. But my question kind of straight up is, based on what Ms. Mercedes commented about, that if there were complaints and there were issues and that they currently cannot take any action, I guess my question would be, what type of action would they want to take short of eliminating an elected position? So I think that's basically what my question is.
I asked Representative Wallace to try to field that question.
Thank you, Representative Klee, for the question. It is my understanding that at present time, because there is no root source of the authority that the animal control officer holds, there is no potential for oversight or supervisory guidance or discipline should the conditions warrant. And it's as simple as that. So that's what we're hoping to get with this measure, is to at least be able to have the position have some accountability and oversight. I'm not certain, or I'm not privy to all the details of what the nature of the complaints are. I don't wish to be. All I know is that we're having a problem with this, and it's already cost the town plenty at this point in time with the lawsuits, multiple warrant articles, and and after all that time has passed, we get rid of the position. So now that court order is now null and void, because we did vote to remove the elected ACO position and have since subsequently reinstated it. So that court order is, it's ancient history at this point in time and has no effect. So here we are.
Thank you, Representative. The last question for this bill is.
Mr. Chair, may I have a quick follow-up? Just a real quick follow-up, if that's okay.
We're well behind schedule, so please make it quick.
No, that's okay. I will pass on my follow-up. Thank you so much.
Okay, the next question and last question is from Representative Van.
Thank you, Mr. Chairman. This question is for Ms. Merced. I guess my question here is, since this is an elected position currently, same as your town clerk is an elected position, I would assume that just as if someone complains about a town clerk, then I'm not quite sure why the animal control officers being an elected position is any more difficult for the town than the fact that the town clerk is an elected position. Can you unravel that for me, please?
So what I would say to that is, I'm not familiar with any complaints that go through the town clerk's office. I probably wouldn't be, because it's so different from the police department. The reason why I'm aware of these complaints that are coming against the animal control position is because, in my opinion, based on these complaints, residents don't understand that the animal control position is separate. So they're coming to the police department looking for relief, and then we're not able to give them anything. What I would say to that is I guess this bill in general and the idea behind this bill came from having a problem. And that's why we're looking for some help on a statute end. I don't know of any problem that is arising from the town clerk. I'm not saying whether it's appropriate, inappropriate, or whatnot. I don't have knowledge of the town clerk. What I do know is there is a problem when it comes to the animal control position. So because there is a problem, that's where this has come from. So I'm not saying that it's not appropriate. I have no idea, but I know that there's a problem with this animal control position, and that's why I'm here to speak on that.
Okay.
Thank you very much.
Thank you, Lieutenant. And this is a complex issue, and we've had a lot of testimony to help us understand. So thank you all.
I have one more question, Mr. Chair.
Who's that speaking?
It's Representative Trelevin.
Okay, please make it fast.
I will. Lieutenant Merced, thank you so much for coming today. And may I ask, why would someone who has a complaint not go directly to the animal control officer?
Probably because that's who they have the complaint with. And if this person is not answering their calls, they're looking for a person who's above them. Just as if someone had a complaint about me, they're going to go to the chief of police because he's the one that's going to be able to do something about that.
Thank you, Lieutenant Merced.
Okay, and with that, thank you, Representative Trelevin. We're going to close the hearing on HB 431. Thank you all for your testimony and for your patience.
Mr. Chair, can you just give me the blue sheet sign up, please?
The previous notation on the blue sheet was incorrect. Here is the correct numbers for this particular bill being HB 431. There were, of those interested in the bill, 21 signed up in support and 5 opposed.
Thank you.
Next, we're going to open the hearing on HB 439. This is regarding the powers of city councils and local municipal governments. We have several sponsors. Is Representative Blasek on the line? Would you like to start?
Hello, can you hear me?
Go ahead.
Hello?
Hello, go ahead.
Okay, thank you, Mr. Chairman, members of the committee. HB 439 attempts to amend RSA 47:17 to make it more constitutionally appropriate. As many of you know, New Hampshire is not a home rule state. There have been 3 attempts in modern history to amend the Constitution to give local authorities more autonomy, but all attempts have failed. The 1981 case Girard versus Allenstown upheld that towns and cities derive their authority from the state legislature. RSA 47:17 gives a laundry list of powers to local authorities, plenty, in fact, to cover any issues I could foresee. But the problem I see specifically is with the line that reads, quote, "They may make any other bylaws and regulations which may seem for the well-being of the city." The term well-being is wildly unspecific. Because of the broadness of the term, I do not believe that this could be considered a specific authority granted by the state legislature. What exactly qualifies as well-being? Well, in the town of Enfield, it apparently includes picnicking in a cemetery, which is prohibited. And let's not forget about the town of Newfields, which made an ordinance that resulted in a reporter being fined for simply reporting. Does the well-being of the town include violating freedom of the press? In Laconia, there is an ordinance that goes above and beyond the state's indecent exposure law to include a ban of showing a female nipple in public, which practically prohibits public breastfeeding. I'm unaware of a state statute that gives the local authority the ability to prohibit public breastfeeding. Let us not forget that the proposed curfew in Nashua. Can anyone show proof that curfews have done anything to curb the spread of an infectious disease? The answer I can say with certainty is no. However, it does plenty to harm the businesses and the liberty of the people. And I cannot find a statute that gives the city the ability to arbitrarily close all businesses at a certain hour. In conclusion, the term well-being is far too broad to be considered an authority granted by the legislature, and I suggest striking the line in its entirety from RSA 47:17. I'm attempting to make this law as constitutional as possible. If the people of this state wish to be a home rule state, we could pass such an amendment. But as things stand right now, well-being isn't an enumerated power granted by the legislature. Should a local authority find a need to add to the already extensive list of powers granted by the legislature, I'm sure the legislature would grant this authority, but well-being cannot be used as a catch-all phrase. Thank you.
Any other questions for Representative Blasek? Seeing none, let's move on to the next speaker, who is Representative Graves from NHMA.
Okay. Very good. Should be all set, Mr. Chair.
Yeah, I'm sorry. I gave you a title of representative.
That's okay. I appreciate the promotion. Thank you. I am Nate Graves. I'm an attorney and lobbyist with the New Hampshire Municipal Association. We are opposed to this bill. The phrase "any other bylaws and regulations which may seem for the well-being of the city" has been in existence for quite some time. The earliest that I could find any sort of reference to that was 1846. So this has been a power given to cities for quite a long time now. And it's a manifestation of what's known as the police power. That is, that according to the Supreme Court gives municipalities the authority to promote such varied interests as public health, safety, morals, comfort, and the protection of prosperity and the general welfare. And that comes from a 2019 New Hampshire Supreme Court case. I think it's really important to recognize that this is a power that was granted by the legislature to city councils to make the bylaws that they need to make to deal with local issues. It's not broader than that. There have been a number of cases over the last century and a half about this power and how it operates. And it's clear that any city ordinance which would violate the statutes or the New Hampshire Constitution is not valid. The New Hampshire Supreme Court has said that numerous times. But it's this is an important line in RSA 4717 because the legislature's recognized that they simply can't list every possible scenario that would come up. I'm certain that everyone could think of a number of different issues that could come up that are local, that really could be dealt with at the local level, and that would be a real headache if every time one of those came up, the legislature to deal with it, we'd have very long hearings where the legislature would have to mediate between local officials and try to determine what the appropriate response is. And it seems like it would be more appropriate just to leave the authority as it has been for the last century and a half and allow this to be resolved at the local level. I also want to note that Representative Blasek listed some ordinances from towns as well as cities. I just want to point out that RSA 4717 Roman 15 only applies to cities, not to towns. So those ordinances would be enacted under a different statute. And I'm happy to take any questions that any members of the committee have.
Questions for Mr. Graves from the committee?
Mr. Chair.
Yes, we have one from Representative Mangiapudi.
Thank you, Mr. Chair. Thank you, Mr. Grace, for taking my question. You pointed out, yes, it is the local control and this ordinance in terms of changing the for public safety. I mean, during a pandemic, and how often do we get pandemic? So does this intrude on the local control for the public safety during what we are experiencing right now to take that away? And this is my city, and I feel safe that we have this ordinance to keep us safe. Could you allude to that, please?
Thank you for the question. So I really can't answer questions about specific ordinances which may be in front of courts at the moment because part of what we do at NHMA is provide legal advice to cities and towns. So I can't provide any advice that would be relative to any ordinances which may be at issue presently in the courts. But you know, the police powers are broad authority that are given to government generally. And, you know, in this case, they've been narrowed down to the local level. And really, it's important to keep in mind that, you know, this statute has a long history and some of the things that have been addressed have faded into the past. And hopefully, you know, what we're talking about now with the pandemic, you know, next year, this will be passed and any sort of issues that have come up as a result of that can be resolved appropriately and we don't have to worry about that. But that's something that we've seen over time that these issues come up. Local decisions have to be made to confront local problems. They're not to the level that the legislature needs to deal with them. And once they've dealt with that problem, you know, time passes, issues get resolved, and we can move forward.
Okay, our next question is from Representative Porter.
Thank you, Mr. Chair, and thank you, Mr. Graves, for taking this question. As an example, I'd like to know this. If this were to pass and there occurred in a city a situation where a swimming hole became poisoned, would this enactment prevent the city from saying the populace could not use that swimming place?
I don't have the entirety of 4717 memorized, but I think that's a good example of something that wouldn't be necessarily limited here, wouldn't necessarily be listed under 4717 in another provision. This removal of this power would be a fundamental change to local government. And it's something the local government would have to come in front of the legislature and say, hey, you know, this swimming pool is poisoned. We need your authority to close it. Or, you know, we have this issue with these two intersections of these two roads, or something that's so small that it just really doesn't make sense for the legislature to take up its time to deal with.
Thank you.
Next question from Representative Diamante.
Yes, thank you, Mr. Chair, and thank you, Mr. Ness, for taking my question. I'm just curious, where does it start? The legislature can be convened in 10 days to rule on any problems and issues that come up within that 10-day period. And some cities went beyond the governor's emergency order. Do you think that was appropriate?
Again, I can't give an opinion as to any ordinances which may now be pending before the courts. What I will say is this New Hampshire Supreme Court has been very clear in a number of cases where they've said, where they've looked at local ordinances and they've said, you know, it's clear in the statute, and the statute spells out that any ordinance which goes against state law or the state constitution wouldn't be valid. These are really case-by-case bases, so it would be impossible to answer that.
Our next speaker is going to be Representative Testerman. She's on the line. Who's in support of this bill?
I have Karen Testerman, which may be also Representative Testerman, and should be all set to go.
I'm sorry, did I promote you incorrectly?
You did. I am a city councilor in the city of Franklin. My name's Karen Testerman, and I happen to be married to Representative Testerman, so that may be where the confusion is. Thank you, Mr. Chairman, for allowing me to speak on this on behalf of this bill. I want to commend the proponents of this bill because they are trying to make sure that we are abiding by the Constitution in all of our legislation, and going in and actually finding areas in our current legislation where there are minor changes that should be made that now align us more in line with what it was intended. Earlier in last year, I guess it was, in Burt versus Shurtleff, the Supreme Court came back, the New Hampshire Supreme Court came in and said that indeed no branch of state government can lawfully perform any act which violates the state constitution. And in fact, removing the ambiguous language that grants city councils the authority to make laws or ordinances that may seem to be for the well-being of the city is an appropriate sentence to strike out. And that's why I'm in support of it. In fact, in my opinion, the language in 4717 should all be struck except for the last sentence to make it simple, because laws are supposed to be written so that the common person can understand them And going through all the legalese before you get to the actual sentence is very confusing to the common man. And so therefore, I think that it would be appropriate to amend this law by striking everything except for the last sentence that says, no bylaw or ordinance shall be repugnant to the Constitution of the laws of the state, and such bylaws and ordinances shall take effect and be in force from the time therein limited without the sanction or confirmation of any other authority whatever. I am asked that you would pass this bill as ought to pass, and I would be happy to take any questions. I have also emailed the committee my statement.
Thank you for doing that email. It makes it much easier for us to create the bill file. So at this point, I'm going to ask if are there any members of the committee that have questions for Councilperson Testerman? Yes, Representative Lyon.
Thank you, Mr. Chairman. So, Councilman Testerman, Karen, do you know this whole sentence seems to hinge on the single definition of well-being. Do you know what RSA, what that defines the word well-being and what that means?
I do not, and therefore I think that there are times when, yes, there are individual situations, but that is something that I think that we have the ability as elected persons to be able to address on an individual basis rather than putting it into the law books.
Follow?
Yes, go ahead.
So what is surprising, the CDC defines well-being as there's no consensus around a single definition of well-being, but the general agreement that at a minimum, well-being includes the presence of positive emotions and moods, contentness, happiness, the absence of negative emotions. Does that sound something that a city should try to govern through ordinance?
No.
Thank you.
Thank you.
Next, I'm sorry, we have a question from committee member Representative Staples.
Thank you, Mr. Chair. I guess this is a question for Councilwoman Testerman. In RSA 4717, the law governs the sale or barter of junk. If I have an issue with the way the word junk is defined, how does this law help me, and why are you not proposing to change that piece of subjectivity as opposed to the one that you have proposed changing?
If you will, I'm sorry, was that in another section of the law?
Actually, in the same section. It is, hold on just a second. It's line 13.
Wait a second. I don't have the legislation right in front of me.
Well, let me read it to you. Amongst the things that cities can regulate, butchers, petty grocers, hucksters, peddlers, hawkers, and common victualers, dealers in and keepers of shops for the purchase, sale, or barter of junk. And then it goes on from there.
Representative, thank you for the question. And that is why I suggested that all of the language prior to the last sentence in that law be struck. I think it would be, a good measure of the committee to go ahead and amend this bill and strike out everything beforehand, simply because people have whoever put this bill together or this language together in the first place was trying to imagine all the possibilities. And, you know, somebody else can come by and have another idea that is not listed and therefore, or in conflict with it. And therefore you're causing conflict that should be addressed on a issue by issue situation.
Follow up, Mr. Chair, please.
Yes, please go ahead.
Then why do we not have that amended bill before us? Why are we only looking at this one line? If in your judgment, it would be preferable to strike everything prior to that line, why is it we're just considering this today?
Thank you for the question, but I did not write the LSR or the language of the bill. I'm just saying that as testifying on this bill, as a city councilor, I would recommend that that's what be done.
Thank you very much.
Okay, before I go to the next speaker, which will be Representative Corrigan, let me go back to Representative Mangiapane for a second question.
Thank you, Mr. Chair. Part of my question was asked by my colleague just before who spoke, and I am just looking at, this was over a period of time that was this RSA was put into place, and to strike years of work from the legislation and recommending amending to almost clean slate seems to me is overturning a whole work of legislation. Am I?
Representative Mangiapane, can you form that in the form of a question?
Yes. So when previous testimony, Ms. Councillor Tesserman said, strike everything out. So are you testifying to this current bill that we have, or are you testifying to a bill that is not here? You're amending. So I'm a little confused as to where you're coming from.
Thank you for the question. Yes, I am testifying in favor of the current bill that is in front of you. I am merely recommending that maybe you might want to also amend this bill as it is in committee to adjust it. And I don't know what the proper process is for that. That is up to you as the committee members. Thank you very much for your question.
Okay, and the next question is from Representative Mangiapane.
Thank you, Mr. Chair, and thank you, Councilwoman Testerman, for taking my question, although I think my question, based on your testimony, may be best for Nate Grays from NHMA. I'm reading Article 1 of the New Hampshire Constitution, and it says all men are born equally free and independent. Therefore, all government of rights originates from the people, is founded in consent, and instituted for the general good. Is the general good defined?
I do not believe so, but I do think, and thank you very much for your question, I do believe that according to our Constitution, that laws should not be made except by the approval of the people. And so it is the consent of the governed that should be allowed. And in fact, if you really go through the Constitution, it says the general court should only be meeting to address the concerns of the state or the citizens. And so that does not mean that you should be meeting every 6 months for a full time to be introducing a lot of legislation for us to mitigate as citizens.
Thank you. Our next speaker is going to be Representative Corrigan, who wants to speak in opposition.
Mr. Chair, I have been looking for Representative Horrigan since we started, and unfortunately, I do not see him on the Zoom call, either by name or by phone that I can identify.
All right, let's go over Representative Horrigan and go. I believe Councilman McNamara from Lebanon, who wants to speak in opposition of the bill.
Good to go.
Go right ahead.
Can you hear me?
Yes, you're down fine.
Thank you. Good morning. My name is Tim McNamara, and I'm currently serving as the mayor of the city of Lebanon. In your written submittals, you'll find a letter prepared by me and signed by 12 of the 13 mayors of New Hampshire cities. My intent in testifying this morning is simply to amplify on the points made in our joint letter. HB 439 seeks to modify the language of RSA 47:17 to remove the ability of cities to enact ordinances which are not specifically identified in the statute, but are, in the words of the statute, and I quote, "not repugnant to the New Hampshire Constitution or to the laws of the state." Now, while the list of permissible ordinances found in RSA 4717 is exhaustive, many of the topics appear to date from the 19th or possibly the early 20th century and are by no means inclusive of the types of ordinances which are currently on the books of many of our New Hampshire cities today. For example, there is no specific mention in the RSA of ordinances relating to zoning or to sewers or to parking or even to dog registrations, topics which are commonly addressed in many local laws. It is vitally important that cities have the ability to expeditiously react to evolving situations by enacting ordinances to protect public health and safety and to enhance and advance the public interest. This is precisely the reason that RSA 47:17 includes the catch-all phrase that cities may make other bylaws and regulations which may seem for the well-being of the city. I can assure you that in making these other bylaws and regulations, we who represent the citizens of our city are always mindful that such regulations must be in conformance with our state constitution and laws. Eliminating our discretionary ability to rapidly enact ordinances, which we deem to be in the best interest of our citizens, is both unnecessary and unwise. In closing, on behalf of the City of Lebanon and the other 11 signatories to our letter, I respectfully request that the committee find HB 439 as inexpedient to legislate. Thank you for your time.
Thank you, Mayor. I have a question from Representative Clee for Mayor McNamara.
Certainly.
Thank you very much, Mr. Chairman, and thank you, Mayor McNamara, for taking my question. I will be honest with you, I'm an alderman also in the city of Nashua. And when the curfew law came up, or the request, we defeated it very handily. But putting that aside, if we were to pass something like that, and I assume you have the same issue in your city, would the courts not have the right to step in either through a independent citizen or even a legislator to come in and to sue the city? Have you experienced anything like that?
I'm certainly not a lawyer or legal expert, but I'm very confident that the courts would have the ability to step in.
Okay, thank you very much for taking my question.
And we have a question, another question from Representative Rudy.
Thank you, Mr. Chair. Thank you, Mayor McNamara, for taking my question. If this bill was in law right now, how would it hamper mayors like you in the different cities responding to the
Hamper them at all.
I'm sorry, I didn't catch the end of your question, Representative.
Pardon?
You said, how would it hamper us in, and I didn't catch the end of it.
Yeah, how would it have hampered you to, as a mayor, to enact or safeguard the safety of the citizens?
Well, I'll give you a specific example relating to the pandemic. So we had not considered a mask ordinance, and we were reached out to by at least one prominent local small business owner who said that they were having a lot of trouble with voluntary compliance with a mask order that they had enacted for their business, and that they felt that it was not being uniformly administered over the entire city. So we were able to act very rapidly and enact what we felt was a very reasonable mask ordinance, which is still in effect. We had only minimal negative feedback to that, and I think it has been very positive in keeping the incidence of COVID-19 down in the city of Lebanon. I have my doubts that we would have been able to do that quickly if we had to do it through the legislature and get it into into the RSAs. So it would hamper us in what we call emerging situations. Now, these are not ordinances that last forever. They are ordinances that last for the period of time that we deem them to be necessary. And we certainly try not to have more ordinances on the books than we need. So I leave it at that.
Thank you.
And next question is Representative Kim Intel has a question.
Thank you, Mr. Chairman. Mayor, I was wondering if you could give us an example of what the timeline and procedure would be like if, in fact, this ordinance, this bill passed through the legislature and the governor signed it. What would be the procedure for adding an ordinance at the city level?
Well, I would imagine that we would need to get one of our, you're talking about if we required state action to be able to enact an ordinance?
Yes, if you needed state action in order to pass an ordinance.
Certainly. So we would go through one or more of our representatives. We would ask that representative to prepare a bill for passage. They would need to take it before presumably this committee. If it was deemed expedient to legislate, then through the House of Representatives. And so I could envision certainly several months from the time we came up with the idea for an ordinance to the time it was potentially enacted.
And the next question is from Representative Tripp here in the LOB.
Thank you, Mr. Chair. Thank you for taking my question. It seems that if this was to be removed from the law, what would the effect be on ordinances that are existing already? Would they suddenly become unlawful and disappear?
That's a great question, and I don't have an answer to it because I don't know if it would cause all existing ordinances other than the ones that are currently listed there to be invalid. I don't know. It might. Our zoning ordinance might disappear. Our sewer ordinance might disappear. I don't know the answer to that.
Okay, thank you. We have one more question from Representative Porter.
Thank you, Mr. Chair, and thank you, Mayor, for taking my question. I'm listening to all this. I live in a town. It's a little different than a city. But I know that this committee has had to listen to a lot of bills to solve problems for an individual community. In fact, we just listened to one this morning that took an hour. In your opinion, if you needed to get authority from the legislature before you passed a local ordinance to deal with a local specific problem that's happening, would you see a lot of laws being enacted? Do you think that our one-size-fit-all laws for all the states, cities?
Yes, I do. Yes, I do. We all have our own individual problems. We certainly have a lot of common problems, but there are things that come up in one municipality that may not come up in another. And I do see a lot of potential for a lot of one-size-fits-all bills and a very exhaustive list by the time you took care of everything that needed to be taken care of.
Thank you.
Yeah, questions from the committee from Representative Piamonte.
Thank you, Mr. Chair, and thank you, Mayor, for taking my question. Being a Dillon Rule state, you mentioned the pandemic as an example, but outside of that, would this apply to anything you wanted to do? I think that's what the bill is getting at. Can you respond to that?
Yeah, I'll certainly try. I mean, I think that there is a possibility that a municipality could come up with an ordinance. I would hope we did not do it in Lebanon, but someone might, that in fact was repugnant to the New Hampshire Constitution and the laws of the state. In that case, there is a legal remedy to overturn that ordinance. So I think the remedies are there to fix a problem if a problem occurs. I am doubtful that this will happen, that would happen very often.
Okay, next question is from Representative Gallagher.
So this is a follow-up to Representative Porter's question. So if we do see an increase in one-size-fits-all legislation for relating to local issues for municipalities, which committee would you foresee those coming before? Like, would it be this one, the Municipal and County Government Committee? In other words, are we going to be creating a lot more work for ourselves by passing this bill?
I would imagine that you folks would be the first stop, and I would see the potential for a lot of discussions similar to the one you just had on HB, I think it was 431, which was very, very specific. And I could see that happening dozens of times over the course of a year.
Thank you. I think our last person to testify is going to be Nancy Vaughn from the American Heart Association. Just the bill.
Yes, good morning. Can you hear me?
You're fine. Go right ahead.
Okay, well, for the record, I am Nancy Vaughn, Government Relations Director for the American Heart Association here in New Hampshire, and I want to thank you for this opportunity to comment in opposition to House Bill 439 for many of the reasons that you've already heard, so I'll try to be brief on my testimony. Why the American Heart Association is here today is we do advocate for public policies, both at the state level, community level, federal level, to create environments where people can easily make healthy choices, including active lifestyles, access to nutritious foods, and living tobacco-free. We want everyone to benefit from smart and effective policies that promote health and safety, as well as civic engagement. What we don't want to see is for states to block local governments from passing laws that make sense to local communities. It can hurt people where the need is greatest. Limiting local decision-making usually leaves communities stuck in that one-size-fits-all rule that doesn't always make sense for every community. Local governments are uniquely positioned to meet the needs of the people in their communities. They are more connected to residents and more accountable to them. Local residents and local leaders want what's best for their communities. They know how to solve local problems because they see them up close. And when local communities come up with a solution to their challenges and put them come together to put them in practice, the state government should be there to help them improve those and not necessarily strike them down. I won't go into a lot of description because this is in my written testimony, but one example that came to mind when I saw this bill is the impact that it could have on local policies which are designed roadways that are safe for all users. So there's several communities in New Hampshire that have what's called complete streets or walkable communities. And these are roadways that have features and designs that the local communities do to make them safer for both pedestrians and for even motorists. And it also is something that can also benefit businesses by bringing foot traffic to those local businesses. So in conclusion, I urge you to vote inexpedient to legislate in House Bill 439, that states should build the foundation for local communities and basic protections so everyone's treated fairly. Local government should then have the ability to strengthen those protections based upon what they know about their communities. And it's much more effective when state and local governments can coordinate and work in solidarity to localize, build upon, and strengthen minimum state standards to meet those unique needs of communities. So again, I did submit written testimony, and I really hope that we can work together on meaningful and effective policies.
Thank you for your testimony, and thank you again for submitting it in writing. It makes it much easier for us. So hearing no further requests for questions, are there any members of the public that are logged on wish to weigh in? Just by the way, by virtue of the blue sheet are those who are signing in on the bill. There were 156 that support this legislation and 47 opposed. Okay, seeing no additional testimony, I'm going to conclude the hearing
Representative, I'm sorry, Chairman, I do see Cody Belanger has his hand up, and I'm not sure if it's the state representative, but he has his hand up and would like to speak.
Okay, I'm sorry, we'll hear from Representative Belanger.
Good evening, members of the, good morning, members of the committee. Can you hear me okay?
Yes.
Thank you. For the record, I just want to point out, I did have my hand up before you closed the session on the previous bill as well, that I was going to testify, and unfortunately was not noticed. So just want to advise to keep your eyes open for that. And I mean no disrespect of that advisement. So with that, I would like to thank you, Mr. Chair, and the honorable members of the committee for hearing my testimony today on this bill. My name is Representative Cody Belanger. I represent the town of Epping, which is Rockingham District 9, where I am also a selectman. I'm here today to ask you to support this bill. Some cities and towns have gone above and beyond the governor's executive orders based on perhaps party affiliation, emotion, and maybe not even facts. For example, one of the things that my town did was do an ordinance that passed that would require the people of the town to wear a mask coming into town hall, but did not require the people who worked inside town hall to wear a mask. I was the sole dissenting vote against that. As the member from Sandown alluded to, when does this stop? What this bill does is change the line, excuse me. What this bill does is change the line for, quote, for the well-being, unquote, which appears and can be transcribed as a catch-all of authority for local authorities to do as they wish. Let's take the town of Newfields, for example. As the member from Merrimack, who is the prime sponsor on this bill, mentioned, this helped allow a town to pass an unconstitutional mandate from peaceful protesting. Whether you agree where the protesting took place or not, it took it further, and ended up finding a reporter, and was a direct attack on the First Amendment. This concludes my testimony. I ask the committee to pass this bill OTP so that situations like the town of Newfields don't continue to arise.
Thank you for your testimony, Representative Belanger. I apologize for not noticing you before. I have a electronic device that tells me who is in queue to speak, and it did not indicate you at either this bill or last bill. So there may be a technology limitation with the system we're using on it, but I apologize for that. Is there anybody from the committee that wishes to ask a question of Representative and Selectman Belanger? Representative Maggiore, my screen doesn't indicate anybody. Is that correct?
There are no hands up in attendees, but I do see Representative Stavis has her hand raised.
Okay. For some reason, my device is stuck and I can't see that. So Representative Stavis, go right ahead.
Thank you, Mr. Chair, and thank you, Representative Belanger. I just have a question for you. If this law, as currently written, included a provision that no city council could pass a mask mandate, would it be okay with you?
This bill to me has nothing to do with any mask mandate. It's just pertaining to situations such as Newfields and any potential unconstitutional adjustments to that as well.
Follow up, please, Mr. Chair.
Yes, go ahead.
You did mention a mask mandate, I believe, in your town pertaining to the city hall.
Yes.
Thank you.
Okay, if there are no further questions, I'm going to close testimony on HB 439. Thank you. At this point, I'm going to open testimony on House Bill 463, which is referring to how the town clerk is appointed in that community, in the community of Gorham. So we have ready to testify. We have Bill Hatch, an elected official. Are you a select person?
No, good morning. I'm can you hear me okay first?
Oh, yeah, I can hear you.
Okay, thank you. Actually, I'm Representative William Hatch. I
Awesome.
represent the wonderful towns of Gorham and Shelburne. I'm District 6 in Coos County. And thank you, Mr. Chair and honorable members, for hearing me this morning. My legislative history, this is, I think, my 8th or 9th term. In the past, I've served as Vice Chair of Ways and Means, Vice Chair of Finance Division 1. Last term I was Chair of GELCAR, also still serve on GELCAR, and I am currently ranking member of Division 1 in Finance. Before you, I've introduced House Bill 463, and that's to allow the selectmen to appoint the town clerk as opposed to it being a constitutional office or elected office. I submitted this bill at the request of the selectmen, and with you also is our very capable town clerk, Denise Valley, and she'll speak to the wherewithal of this bill and why it was introduced. And thank you, Mr. Chair and honorable committee.
Any questions for Representative Hatch?
Thank you, Mr. Chair. If I may, Mrs. Valley is certainly capable of answering any questions. Because of your overtime, I'm now double doing 2 meetings at once, and it's not working well for me. So I'll acquiesce questions to our town manager, Ms. Valley. She can certainly answer any questions that you may have before you. Thank you, Mr. Chair, and thank you, committee.
Ms. Valley, are you on the line with us?
I am.
Yes.
Can you hear me?
Yes, we can hear you fine. Go right ahead.
Thank you, Mr. Chairman and members of the committee. I am town manager, not town clerk, as Representative Hatch initially stated. So very quickly, the Gorham Board of Selectmen is respectfully requesting that they be given the authority to appoint the town clerk tax collector. Currently, we have one person filling both positions along with a deputy. The position is currently staffed by a full-time person who's been with us for 10 plus years, and the deputy is the former full-time clerk tax collector who was with the town for more than 35 years. Our full-time town clerk is expected to retire within the next couple of years, but may do so sooner, and our deputy wishes to retire within a few months. The full-time position pays over $50,000 with benefits. There is no one that we know of in Gorham who is qualified and is willing to be elected to the position. We do know of at least a couple of financially skilled people who would take the position if they were to be appointed. In Gorham, the town clerk tax collector is responsible for collecting just over $4 million in revenues, including over $640,000 in motor vehicle registrations. The town recently updated its software that provides for the assessment data to be exported to a Collect Pro system, which then generates the property tax bills. This system is very complicated and takes quite some time to master. For someone who is not very good at computer programs, to attempt this would be disastrous. The clerk side of the position keeps the registered rolls and election documents in the same office as the tax collector. The town long ago determined that the only way to get someone to competently manage both roles was to make a combined position and to compensate that person accordingly. We fear a situation where we are statutorily required to hand over these duties to someone who is unqualified but has been elected based on their popularity or because the position is uncontested. The board wishes to appoint a qualified applicant that has the relevant background, financial training, and the required skills and experience necessary to adequately perform the duties of the town clerk tax collector position. We feel that this position is of vital importance and that it should be filled with the most skilled and experienced applicant possible.
Thank you. Representative Porter has her hand up to ask a question.
Thank you, Mr. Chair, and thank you, Ms. Valley, for taking my question. I think at the beginning of your testimony, you said you knew no one that was qualified that was willing to run, but that there were qualified people who might serve if they were appointed. Can you explain that a little bit further to me? There's people you know who could do the job, but they don't want to put their name on the ballot. Is that what you're saying?
I am saying that they would like to be appointed so that they are assured that the position is theirs longer than just a 2-year term. And the current town clerk does not mind the fact that she is appointed. She's been here for 10 years and she's fine with that. But we are really worried about a person running that does not have the financial skills and background that would just win this, win an elected position just based on the fact that they want to, give it a try and they don't really have the skills to do it. And it's a very important, vital position to the town. You're dealing with a lot of money and we don't want that to happen.
Can I have a follow-up, Mr. Chair?
Yeah, follow up, go ahead.
And so usually in a situation like that, where there's someone who doesn't have the background, there's a deputy that works with them that actually is the one that coaches the clerk and makes sure that everything is the way it should be. But you said your deputy is also retiring?
That's correct. She actually wanted to retire last December and has stayed on.
So do you appoint your deputies or do they get elected?
The deputy is appointed.
Thank you.
And the next question is from Representative Pimentel on the committee.
Thank you, Mr. Chairman. Thank you, Ms. Valley, for being here to answer our questions. If this becomes an appointed position and you're unable to find somebody who is a resident of Gorham, because it is an appointed position, would you be able to go outside of the town to find a qualified person?
That is one consideration. Right now, our other appointed positions in town, we are able to appoint from outside of the town. I do know that one of the people that is interested in the appointed position is a Gorham resident.
Okay, the next, I'm sorry. Yes, sir.
Follow-up is, I understand that the elected position is town clerk, tax collector. I'm not sure if they're two separate positions, but the assistant, is that person selected by the board or the elected official?
That person is typically right now selected by the town clerk, but with the approval of the Board of Selectmen. She usually makes sure that they're fine with whoever she's appointing.
Thank you.
You're welcome.
Next question is from Representative Majapudi.
Thank you, Mr. Chair. Thank you, Ms. For taking my question. So changing this to appointed position, would this help with frequent turnover of election every 2 years, especially performing an important task as tax collection, which is the revenue for the town? Would this help making a stability and continuity?
I do feel that this would make a big difference as far as having someone in the position for a longer amount of time.
Okay, next question is from Representative Trillette.
Thank you very much, Mr. Chair, and thank you, Ms. Valley, for coming today and testifying so concisely. I have just two quick questions. You're welcome. I have two quick questions. What's the population of the town of Gorham?
We are just under 3,000 people.
Okay. And my second question is, I heard you say earlier in your testimony that the town clerk who's currently there was appointed. How did that happen?
No, I was saying that the deputy was appointed. The town clerk ran for her election.
And so the town clerk has run, I'm sorry, every 2 years for election?
She has.
Okay, thank you so much.
And the next question is from Representative Piamonte at the LOB here.
Thank you, Mr. Chair, and thank you, Ms. Village, for taking the question. I didn't know if I caught it correctly, but you said you have a person in town that's afraid to go on the ballot that's qualified. Is that true?
Yes, and I wouldn't say that she's afraid. I would say that she wants to have the position if it's an appointed position. She does not want to have to run for election and then worry about running every 2 years after that.
Follow up?
Yes, I'm sorry. The question of stability came up on this. Have you had any problem in the past with stability? I thought I heard you had a person who's been there for years.
We are worried about stability in the event that someone runs that does not have the qualifications needed to do this position. And that's where the instability would come in.
Okay, next we have testimony from Kelly Roberts from Deerfield, who wants to speak in opposition of the bill.
Hello, can you hear me?
Yeah, very good. Go right ahead.
Hi, my name is Kelly Roberts. I'm a lifelong resident of Deerfield, New Hampshire. I am also Deerfield's elected town clerk tax collector. I was first elected in March 2018, and I am up for re-election this year. Prior to being elected town clerk, I served as the deputy town clerk tax collector for almost 11 years. I have spent over a decade working for an office that directly serves the voters and the public. I vehemently oppose HB 463, which seeks to turn the Gorham Town Clerk Tax Collector's office from an elected position to an appointed position. I ask that everyone here oppose this bill. This is a bad bill, and I'll explain why. The town clerk is a local election official that administers town, state, and federal elections within their communities. This fact alone is reason enough to always keep the clerk in an elected position. An elected official such as the clerk can never be perceived by the voters and the public that they serve as being influenced by any board, any committee, or any agenda. Purity of elections and faith in the process is integral for democracy. The community sees the clerk as part of this democratic process. The clerk is someone voters and residents are comfortable talking with outside of the Board of Selectmen. Clerks provide a neutral space for residents and voters to conduct their transactions. If the clerk is placed under the board's direct supervision, that neutrality and autonomy is gone. That public trust is not as strong. The perception of the clerk serving the public first and foremost is replaced with the notion that the clerk serves the Board of Selectmen's mission and the public second. The quality of service is diminished. The clerk serves the public faithfully and impartially. The role of the clerk is to be autonomous and accountable to the public. This fundamental principle allows the clerk to perform their duties with integrity and transparency. The clerk is not an arm of the Board of Selectmen or the governing body. They are a stand-alone elected leader in the community. They do not work for the Board of Selectmen, rather, they work with the Board of Selectmen and vice versa. A clerk does not work for a town manager or a town administrator. Rather, they work with them to meet the town's needs. An elected clerk is more service oriented as they directly serve the public doing transactions. The Board of Selectmen's role in the day-to-day transactions is a conflict of interest and a potential violation of state and federal privacy laws. They have no business supervising them, and they have no good reason to be privy to the transactions they conduct. Those who support appointing a town clerk argue that they can hire a more qualified person for the job. This simply is not true and a weak argument. The truth is, there is no college degree to become a town clerk. To become a clerk, you must learn from other clerks and state agencies and clerk associations that you work with, period. You don't learn to be a clerk from the select board. When a new clerk is elected, they attend clerk trainings and network with other clerks. The New Hampshire City and Town Clerks Association offers training and a certification program. Those who support appointing a clerk suggest that it makes the position less about a popularity contest and more about the qualifications. This is not the case. A person who runs for clerk is someone who accepts public life and is willingly choosing to serve their positions through the electoral process. It's not a popularity contest, it's an election process. When you remove an elected position, you are removing the opportunity for the community to vote who they want. You are literally taking away a vote from the people. New Hampshire has a strong history of amazing clerks. It is a tight-knit group. We stick together and we learn from each other. If clerks became appointed, they may not be as respected from their clerk colleagues who value the democratic process. People have actually said to me that they feel bad that I have to rerun for office every 3 years. While I'm flattered that they are concerned for my future, I also recognize that there needs to be an awareness raising in New Hampshire that clerks are not like other departments or other elected officials. We are a unique hybrid. Most of what we do is based in statute, is process related, and is fundamentally rooted in the democratic process. There really is nothing that the board needs to supervise. If a board is worried that nobody will run for clerk, they shouldn't, because there will always be someone to step up to the plate. A point of clarification, there are some positions within municipal government that may be better suited as an appointed position. There are valid arguments that support this. However, this does not apply to the clerk. The clerk position is an entirely different animal, a special hybrid of statutory roles and duties. Some towns have a separate town clerk and a separate tax collector's office. There are provisions under the law to allow tax collectors to be appointed. Some towns have combined the two positions, making the town clerk tax collector's office one office. This is common in many towns. In combined offices, the town clerk is both the town clerk and the tax collector, and it has to be an elected office because of the town clerk's duties and responsibilities. There are so many reasons why this is a bad bill. I did reach out to the clerk in Gorham, and she opposes this bill. This is not the direction we want New Hampshire to go in. The clerk is a standalone leader within a community for a good reason. Separation of duties safeguards against abuse of power and provides balance while maintaining a positive public perception. This is not a partisan issue. This is a fundamental issue of the local democratic process. James Madison, known as the father of the Constitution, is famously quoted as saying, "If men were angels, no government would be necessary," end quote. But men are not angels, and thus political powers, even at the municipal level, must be separated and balanced. Thank you for letting me speak.
Thank you, Ms. Roberts. We have a question from Representative here in the LOB.
Thank you, Mr. Chair, for taking my question. Thank you for taking my question. Actually, there's I have several questions, but I can maybe just sum it up. It appears that the clerk tax collector position is common in your area. It appears that the selectmen are concerned with the tax collector position being filled by someone who has the skills necessary. But it also appears that in Gorham, the clerk isn't actually doing the tax collector duties. He or she has an assistant doing it. So it doesn't seem to be apparent why the clerk has to be appointed when they're not doing the tax collector duties. Is that correct?
The town clerk tax collector is one position in Gorham. So both the town clerk tax collector and the deputy town clerk tax collector are doing both town clerk and tax collector duties.
Okay, I have two other hands raised, but I want to make sure that we're pursuing questions before we go on to additional testimony. So David Scanlon, do you have a question or do you want to offer additional testimony?
Thank you, Mr. Chairman. I'd like to offer additional testimony.
So we just hold on that for a minute. Daniel Healy, do you have a question or do you want to offer additional testimony?
Mr. Chairman, this is David Scanlon. I'd like to offer additional testimony.
Right, I understand that, Mr. Scanlon, but I want to go questions first. Mr.
Okay.
This is Daniel Healy. I am the Derry Town Clerk, and I too would like to offer additional testimony.
All right, before we go to you two gentlemen, I'm going to go back to Representative Porter because I believe she has a question.
No, Mr. Chair, I put my hand down. My question was answered by someone else.
Okay, then we're going to go to Mr. Scanlon for additional testimony.
Thank you, Mr. Chairman. My name is David Scanlon. I'm the Deputy Secretary of State. And as been our practice in similar bills in the past, we vigorously oppose an attempt to make a town clerk appointed. I think that Clerk Roberts did a fantastic job in explaining the issues involved. So I'm not going to repeat that testimony, except to say that this office interacts with clerks in two main areas, elections and in vital records. Elections is in New Hampshire is built on checks and balances through the entire process. And the elections, whether they're local, state, or federal, are conducted at the local level. And the clerks, along with moderators and supervisors of the checklist, are very integral to that process. And it is critically important that they maintain their independence in that process, that they don't have to answer to somebody that may potentially try and impact decisions that they make in a critical role of making sure that our elections are free and fair and full of integrity. So I would simply echo Clerk Roberts' comments in that respect. Vital records is also another area where we deal with the clerks. Clerks are tasked with maintaining the privacy of citizens in your town in terms of data that they have to report related to births, deaths, marriages, divorces, adoptions, and they have access to all of that information. Under law, excuse me, they have to keep that information private and confidential. They should not be placed in a situation where somebody that has their thumb on them through some supervisory role, can manipulate that person. And so obviously that's an area of concern that we have. And then the final thing that I would like to say, just to reinforce what Clerk Roberts said, was that the clerks have an incredible training and certification process. It is very involved. I would equate it with taking graduate courses at college. They are very committed to that. We participate in those as instructors. And I can tell you that the clerks, without exception, in New Hampshire, take that process and their role very seriously. So I would just start off where I began and say that we oppose this legislation, and I would be happy to answer any questions.
Thank you, Mr. Scanlon. I believe Representative Lascelles has a question.
Yes, thank you, Mr. Scanlon, for taking my question. I'm particularly interested in the, with respect to elections. I would like to know the relationship between the town clerk, the supervisor of the checklist, and the moderator. Is there a connection, a reporting responsibility for those three people? Does the checklist supervisor, who does the checklist supervisor report to?
They are all independent entities, but they have to work together as a team. They all have very distinct roles that are described in the statutes. The supervisors of the checklist are responsible for voter registrations. They are the only elected body in the state that can put names on the voter checklist or take names off the voter checklist. The Secretary of State does not have that authority. That role is the supervisors of the checklist. The moderator is the chief election official on the day of the election and has significant responsibilities in terms of making sure that the polling place runs smoothly. On the day of the election, that person is the general, the top person in terms of deciding how the processes work under the confines of the statute. And then the clerk has duties that are well beyond election day because they are responsible for the ballots. If it's a local election, the clerk is responsible for designing and printing the ballots. If it's a state election and local elections, the clerk is responsible for making sure that the absentee ballot request forms are received and processed and that the voters receive their ballots. They're responsible for keeping track of the ballots leading up to the election, making sure that they get delivered to the polling place, and then is responsible for their safekeeping after the election is over. All of those entities, this moderator, the supervisors, and the clerks have a role in recounts where they all make up the board of recount along with the selectmen. And you know, it's a well-oiled machine in New Hampshire. In almost every instance, these different elected election officials just work incredibly well together. And that's borne out by the fact that New Hampshire, compared to the rest of the country, has very smooth elections.
A question from Representative Klee here in the committee.
Thank you, Mr. Chair, and thank you, Mr. Scanlon. My question to you is, on a city level, the city clerks do, I believe, all of those duties that you had said. Maybe there was something that I missed. Why does it work okay in the city and not in the towns? And I know government is completely different from one to the other, but they have the same responsibilities of bringing the ballots, et cetera, to making sure that the checklist is done. As a matter of fact, I know that you stole our previous city clerk to work within your organization, and we miss her dearly, but we do love our current one here in Nashua. Can you explain why it's not as an issue for our city clerk to not be elected versus a town clerk?
Yes, thank you for that question, Representative Klee. So in the cities, the city clerk is the chief election official in the city, and the city clerk is responsible for the uniform practices and training and everything that takes place for elections that are held in the city, whether they're local, state, or federal. However, every city has a ward or wards, depending on its size, and each of those wards has an elected board of selectmen, an elected moderator, an elected ward clerk, and those are the individuals that are responsible for conducting the elections in the ward. Under the statutes, there is no distinction really that is made between a town or a city ward in terms of how the election process is run.
Thank you.
Follow up, Mr. Chair.
Quickly, please.
Okay, I will. So basically what you're saying is that the difference is the elections, but the other duties that were described as far as, I think someone talked about marriage license, et cetera, those are still done by our city clerk without an elected official. Is that correct, or am I mistaken on that?
No, you're correct. And the clerk has many responsibilities that go well beyond elections and vital records. And obviously they deal with motor vehicle registrations, dog licenses. Those are areas the Secretary of State does not get involved in, but the clerk does have those responsibilities.
Thank you. I want to move now on to our last speaker, Mr. Daniel Healy. Please identify yourself, where you're from, and whether you support or oppose the bill.
Daniel Healy, I'm the Derry Town Clerk. I'm representing New Hampshire City and Town Clerks Association. And our association is opposed to this bill. We're opposed for the reasons that Clerk Roberts mentioned. Everything that she said in her testimony is exactly how our association feels. Representative Tripp brought up a comment on the combined office. A town can vote to split the office of town clerk and tax collector after they have voted to combine it. So if Gorham believes that they're going to have an issue down the line with their tax collector not being trained well enough, they can split that office off of each other if they feel that's necessary. Our association does provide a lot of training. We have a 3-year certification program that most new clerks attend. I attended it my first year. I graduated in the 3rd year. I started 5 years ago with no experience as town clerk, no prior experience. And through the association, through reaching out to other clerks, I learned the position. I don't really believe it's a good excuse to make this an appointed position because they don't feel that someone will step up, that someone is there able to do the job. They would be able to find someone to do the job and to fill the role as town clerk. So I would suggest to them if they feel that the tax collector portion of it, a resident's not going to be able to do, they can split that off. And that's what they should do. Our association does not like this bill. We oppose this bill, and I'm open to any questions.
Okay, are there any final questions for Mr. Healy from Derry?
Mr. Chair,
Yes.
a quick question.
Yes, Representative Guthrie of the committee.
Thank you, Mr. Chair. Is it fair to say that Gorham should not have any fear if we do ITL this bill? And that seems what the bill is for a specific town. I know my question really is, if the selectmen in the town have a concern as to who would be at least a candidate, can't they make sure that the town clerk tax collector retires in between the elections? They would appoint somebody, let them get real good training, and then that person run. So couldn't the selectmen have some input to that position if it has to be appointed in between the elections?
So they would. The person appointed would be appointed to the next annual election. So it would be less than a year appointment, but if they did it right after a town election, the person would be in office for about a year before the following election would take place.
I know in my town, that's what we did, and it worked out good. The person got trained, and she ran and is still running. And asking for a 3-year term is not too much. There's no guarantee, but that's what the job offers, and I don't think you can change that.
Yes, and our association is very helpful with new clerks. They have a new clerk workshop. They make sure to reach out to all the new clerks, let them know what help is available. A clerk that's been doing the job for a while will even go to that town and sit there with the clerk and assist them and make sure that they know what they're doing. So we do have the resources as an association to assist new clerks. So I don't really see this as an issue. And it's really not an issue yet for Gorham. They're kind of looking down the road. But I mean, the towns are going to lose their clerks to retirement. It happened in the past where they take other jobs, either at the state level or with the city or just a different position, maybe a town manager, town administrator, and the town moves on. They find the right person, they train that person, and they continue servicing the town.
Thank you.
Thank you. We have one more hand up, Representative in the town committee. I would ask if this is not something new, that we hold the question. I'll defer to you.
Thank you. This is a new question. Thank you, Mr. Chairman. Thank you, Mr. Healy. Are the training you mentioned through the association, is that available to just elected clerks, or can an aspiring clerk, someone who's planning on running in the future, take the same training? Thank you.
So right now, it's not open to someone that's not in the position, but it is open to someone that's working in the office. So it's not open to just any resident of the town. We had that question come up. I'm actually on the certification committee. I'm the vice chair for the association. You have to be in your position.
I just have a message from Senator Guyton. He wants someone to call in.
Thank you.
You or Bill.
Okay.
Close the hearing on HB 463 and move to open the hearing on HB 467. Going back to 463, however, let me report that of those interested in the bill, we had 3 in support and 22 in opposition. For the record. All right, HB 467 is a bill relative to current use tax rate eligibility. And let me ask if we have Carrie Guitar, I'm pronouncing that name correctly, from the New Hampshire Wildlife Federation, who opposes the bill, would like to speak.
Mr. Chair, I apologize for interrupting, but I believe the prime sponsor is on the line to introduce the bill.
And the prime sponsor is who?
Representative Ellen Reed. I could be wrong, but I do believe she is here to introduce.
I'm here if you can hear me.
I can hear you. I don't have you on the list to speak, however. But if you're the prime sponsor, go ahead and introduce the bill, please.
Thank you, Mr. Chair, and thank you, Honorable Committee. For the record, my name is Ellen Reed. I do represent Rockingham 17, which are the towns of Newmarket and Newfields. I also have a biology degree from Vanderbilt University. I have another legislator as well who would like to speak on this bill, who has experience with conservation issues. She is involved perhaps in a family emergency. I believe she's on and ready to testify, but I just want to make you aware in case she has to step away. So I would like to start by talking about the purpose of our current use RSA. Obviously, anytime you touch current use RSA, you're going to have a whole lot of people interested in the issue and concerned about whether or not the changes are going to impact them. The current use law RSA 79A states, I'm going to shorten it, it is hereby declared to be in the public interest to encourage reservation of open space, thus providing a healthful and attractive outdoor environment for maintaining the character of the state's landscape and conserving the land, water, forest, agricultural, and wildlife resources. So I just give that very briefly as background as to the idea of why we have current use law at all. Obviously, current use, as we look at it, the purpose is to protect farmers and other stewards of our open spaces who provide us with a lot of necessary services while protecting our open space, while engaging in that conservation, from the highest and best use tax rate that private businesses and other entities that are not involved in being stewards of our open spaces are doing. However, I would argue, and I think it's pretty obvious from the RSA that I just read, that if the organization is actually involved in damaging our wild lands, our wild habitats for our wildlife, and not conserving it, then it would be an injustice to deny from those municipalities that tax revenue that those businesses should be contributing to when they are in fact not contributing to the conservation of our wild lands. And this is exactly the case, not frequently at all. And I want to make it very clear, because I was reached out to by a whole bunch of different farming organizations and private farmers worried about this. My intent in this is not to remotely touch anyone we consider to be in the farming or agricultural world. Those people provide us with food, and our tradition is deeply rooted in farming. I would never even think to do that. But we do have a couple, not a lot, it looks like probably 2, privately owned recreational hunting clubs dedicated to private membership recreational hunting of exotic species. And there have been numerous examples of those exotic species causing problems and in fact having the capacity to become invasive. New Hampshire, primarily, I am concerned about one. New Hampshire has the largest private membership-based exotic species recreational hunting club east of Mississippi. You may know of it. It's called Corbin Park. It is famously private and exclusive. We don't have a lot of information on, for example, their membership and dues, but from what little information has been made available through just personal testimony, it appears they have maybe a couple dozen members, almost entirely from out of state, a few maybe in state, paying about approximately a six-figure yearly membership due to hunt exotic species on this private grounds. It is a 25 or 26,000 acre property and with approximately a 26-mile perimeter. We don't know, as I said already, we don't know all of the species that they harbor there for this private hunting recreation, but we do know that they do quite a bit of harboring of Eurasian wild boar. For those of you who may not know, that is one of the species that has become famously invasive in the South and in the Southwest in devastating entire ecosystems down there, one of the species. They also harbor elk. Elk has the capacity to compete with our native white-tailed deer, and also elk famously harbor a number of diseases that are easily transmissible to livestock animals. The elk, as far as I know, have not yet become a real world issue, but certainly the boar most definitely have. Numerous examples of the boar escaping the facilities, causing real awful, and I would implore you to ask the Fish and Game Department, I'm on the Fish and Game Committee myself, about the devastation that those boar have done to our New Hampshire public lands in terms of rooting up vegetation and damaging habitat. Also, the boar have damaged private property as well. There's numerous examples of the residents in the area that have had their private property damaged. The boar have also caused traffic accidents and have actually procreated outside the park. Now, because this is a very private, these are not animals that Fish and Game can regulate. These are privately owned animals. It would be the same as if you had cows on your property. So when they escape, they are still considered under law to be the private property of the park. But the escapes have happened so much that now the boar that have managed to escape, while the law protects Corbin Park to say they can charge for the killing and taking of those animals, Corbin Park has had to basically waive that because just to enlist people to help control the damage that the wild boar are doing. So the other facility I'm aware of is a game bird facility where, and I believe the AKC has submitted testimony. I don't know if she's here to testify. And the idea is that these facilities are breeding or harboring exotic game bird species to train hunting dogs, which is fine, except for the fact that, again, anytime you have the potential of a species becoming invasive, we're talking about encroaching on our natural New Hampshire lands. And I would posit that we actually do have quite a number of native game bird species that any training facility could use in order to train hunting dogs. Also, I would like to point out that there are a number of special laws. In fact, the trespassing signs at Corbin Park highlight the fact that they are protected by special law. For those of you who may have seen some of the news articles, Corbin Park was established by I believe a steel or railroad magnate named, Austin Corbin. in the 1800s who was quite famously very wealthy and powerful. And just as a way, not as a way to inject any other issues into this, but just as a way to go ahead and acknowledge the articles that have come out. Yes, he originally created the park as a private club for wealthy white non-Jewish men. I'm not trying to inject that in there, but there have been a number of news articles on that. But that is not my issue. My issue is strictly on conservation. So as I said, I do serve on the Fish and Game Committee. I do understand and respect that hunting, when in the context of science-based game management plans, is very important and helpful to our ecosystems. We are not talking about hunting in reference to our natural native species. We are talking about bringing exotic, possibly invasive species that are doing damage to our lands. And then on top of allowing that, which I'm not suggesting we ban that, but on top of allowing that, then giving them a very, very substantial tax break, which by all rights should go to those towns. So yes, we are talking about the privatizing of wildlands where they stock exotic animals for private people to kill privately owned animals.
Okay, Representative Reed, are you willing to take some questions?
I am. I would just like to close very briefly with saying that I have been, again, reached out to a number of farm and other concerned interests. In every single case, I explained to them my intent and asked them if there was any language at all that they would like me to use to amend it. My goal is to protect the farming community. And so I have not received any language from them, but I am still very, very much willing to work with anyone who would like to detail this language to make sure our farming community is protected. But yes, I will take questions.
And before you do that, can I ask you to submit your written testimony to the committee?
Sure.
Representative Porter has a question.
Thank you, Mr. Chair. Let me get back on screen here. And thank you, Representative Reed, for taking my question. I'm not sure you know the answer to this, and I know I don't know the answer to this. Years ago, when my life was different, my family owned a parcel of land that we had in current use, and we used it for logging. And so our property taxes were reduced because of that, but we did have to pay a timber tax on the proceeds of the logging that went to the town. Do you know of any other use of current use land that would produce an income for someone, produce revenue, profit, that doesn't have to pay anything into the town in terms of taxes as a result? I'm assuming that farmland is a different thing, but any other use of current use land that makes a profit for the owner, whereby the owner doesn't have to compensate the town for the use of the land?
Thank you very much, Representative Porter, for the question. Other than the things that you mentioned, I know of none. Essentially, businesses, in the sense that we think of businesses, would always have to pay some form of tax. And certainly that's even the case for farms and as you mentioned, logging. I would say, as I stated in the beginning of my testimony, that in the case of agriculture, in the case which I would extend to the harvesting of timber, these things, especially when they're done by, and I think we're mostly concerned about the small farmer and the small time timber harvesters you yourself were. These things can be done and should be done in a sustainable way that works with our natural ecosystem and not against it. So we do clear lands for farmland, for example. So that's not simply not using the land. You are using the land, but you're using it in a way that is beneficial for the ecosystem and beneficial for the residents as well. This is why we don't want to tax them at that full highest and best use rate. They are protecting the land and giving us something. In this type of situation that I've outlined, and I believe that the organization that operates Corbin Park is a nonprofit and is not paying any kind of taxes. This is a situation where it's not even really a business, it is a private club that is completely cut off, except for the fact that their invasive animals are escaping and causing damage. But there's really no oversight. Law enforcement, to my knowledge, in all of the years has only been on the property once, and that was only because a person was killed on the property. So there's really no oversight over this particular property. So I'm not suggesting changing those laws, but I'm saying there is no rationale, therefore, for then giving them a giant tax break. They aren't doing the things that the other entities like the timber harvesters and the farmers are doing for our ecosystem in our community.
Thank you.
Next, we'll go to Representative Trelevin and then Manager Prudi after that.
Thank you, Mr. Chair, and thank you, Representative Reed, for coming and testifying. I think you may have just answered my question, which was in regard to the bill is addressing the issue of the fact that a private club is receiving a tax benefit from the state of New Hampshire where they're not providing a benefit back to the state of New Hampshire in the sense of land that is open for hiking or biking or walking or anything else because it's a private club. And your remedy is to make this private club pay the highest and best use for taxes, not the current use tax, because they are not benefiting the state. Am I correct?
You are 100% correct, Representative Trelevin, and it was very succinctly and well put. The details of Corbin Park, it is entirely surrounded by the whole 26 miles of perimeter by a 12-foot high fence, which the boar are very capable of burrowing under. But there it's posted with no trespassing, and it's extremely well enforced. And it's actually a lengthy and kind of ominous sign that I'm happy to share with the rest of the committee. So it is not open to any hiking, bird watching, any kind of recreational use outside of the people who are able to afford the six-figure-ish membership dues. And as you pointed out, almost all of the open spaces that we currently do give current use tax credit to can in fact enter into those agreements to allow their spaces to be open to hikers or even hunters that are actually hunting our actual native species or what have you, any kind of recreational activity. But this is completely cut off in its own bubble, except for the fact that they're private animals that are invasive keep escaping.
Thank you, Representative.
Next, we have Representative Prudi.
Thank you, Mr. Chair. Thank you, Representative Reed, for taking my question. You talked about the invasive non-native species of animals breeding or growing in this. How are their feeding habits changing our ecosystem in terms of vegetation because they are non-native? And I have two-part question to that. And also, you talked about the diseases that they bring, how it is affecting our natural ecosystem in terms of our native animals as well as the native vegetation, because we are bringing a non-native invasive, could become invasive and could affect our natural ecosystem in New Hampshire, which is our prime jewel, or that's our basic treasure.
Thank you so much for the question, Representative Magnapudi. I, not being an employee of the Fish and Game Wildlife Division, don't have detailed information, but they do have it on their website. And I'm very happy to send those links over to you all in the committee. However, very broadly, I can say that the wild boar, I know when we talk about endangered species, we frequently don't talk about plant species, but we do have endangered plant species. Wild boar can upset the habitat for those endangered plant species as well as habitat for, or not just endangered, but just threatened animal species as well. In terms of the disease, and the wild boar, I think you can make a good argument that they already have become invasive because there are instances of individual boar that appear to not have come directly from the park, but maybe have actually bred outside of the park, as they have done very extensively in the south and southwest parts of the country. The disease that I mentioned in particular with reference to elk, which as far as I know, has not escaped the park yet. I mentioned that the elk could outcompete our native white-tailed deer, but more importantly than that, and possibly moose, though they do use slightly different food sources. But more importantly, they are a giant carrier of several diseases, including wasting disease, which is currently really impacting New Hampshire's, both our threatened moose population and our native white-tailed deer population, which is not as threatened, obviously. But that is the extent of my knowledge, but there is more information that I'm happy to provide to the committee.
Can I ask a follow-up question, Mr. Chair?
Follow-up though, let's be understand that we have 9 additional speakers on this bill.
No, I understand.
Any more questions may come
Yeah.
up. Go ahead if you might have a follow-up.
Yes, follow-up in terms of we address the animals, then the birds, gaming birds. So there's a whole system, ecosystem that's being shifted because of introducing non-native species, not only birds, animals, plants, and how the pollination happens outside the farm, outside this private land, and how it affects the neighboring farmland because of the vegetation changing.
It is, thank you, Representative Magnapudi. It is a prime tenet of conservation sciences, all of the different conservation science disciplines, that we do not introduce non-native species, or there have been examples of the attempt to introduce non-native species for other control issues, mainly to deal and remedy issues that were caused by other non-native species being introduced. So it is a tenet to not do that. And certainly, as you mentioned, our tourism industry, which comes to see our wild lands, is our number 2 business in New Hampshire, number 2 industry. So we want to protect that at all costs.
Okay, next we have a question from Representative Lascelles and here in the LOB.
Yes, thank you, and thank you for taking my question. It seems to me that this bill is attempting to control non-native species by taking away the current use. Aren't there other laws that we have in New Hampshire for controlling, for instance, wild boars?
Thank you, Representative Lascelles, for the question. So the short answer to that is essentially no, unless I think you were purposely bringing them in and purposely releasing them. But if you think about any of our farms, while I did exclude non-domesticated species in order to exclude all your regular farm species, but a cow is non-native, right? You can bring a cow. There's no regulation on you except for maybe your municipal zoning ordinances. There's no real regulation on you for bringing a cow into New Hampshire. And if the cow escapes, it escapes. A lot of domesticated species cannot become invasive because they, over many years of breeding, have become utterly dependent upon human beings, especially in our rather unforgiving climate. But we do know, obviously, wildlife in New Hampshire exists, and so there are plenty of species that can adapt to our climate. So there's not a whole lot of good laws in terms of you can't introduce. There's some good laws around aquatic species. I think you can be fined for not cleaning off the hull of your boat, for example. But I don't know of any laws that would do that. And more specifically to the point, while yes, my main concern is invasive species, to say that I'm simply trying to get rid of people bringing in non-native species is not exactly the point of the bill. The point of the bill, as Representative Trelevin very succinctly stated, is that we give current use for a very specific reason. We are getting something out of it, either in the stewardship of our wild lands, in our ecosystem, or in the sense of provisions of food, preferably in a sustainable way. We aren't getting anything. The state of New Hampshire is not getting anything from this particular type of facility. It is not helping our ecosystem. It's damaging our ecosystem. And these areas are not open for people, tourists or otherwise, unless they have a good chunk of money to enjoy those lands. And again, 26,000 acres.
Representative Mangiore has a question from the committee.
Thank you very much, Mr. Chair, and thank you, Representative Reed, for taking my question. I'm curious if you have considered or would consider putting in some reference to how we define non-native and non-domesticated species so that it removes the ambiguity? And I apologize if that question was asked before.
Thank you so much for that question, Representative Maggiore. I could say that me putting this bill in and trying to figure out what language would be suitable was a heartache, because I understand the need to balance ambiguity, like intentional ambiguity and broadness, with specificity. I opted for the simplest language. I mean, you can also use that argument around the word harbor. Like, what does it mean to harbor? And what I did instead is I just put it out in the simplest language possible, thinking that if I tried to drill down on different details, that's more that, for us to fight over. And I want to just put out once again that I put it in this broad language, or simple language, not really broad. But despite the fact that there are definitions for invasive under rules, I don't know about statute. And also domesticated, we actually do have statute that does define domesticated species already. So we do have some definition already, but I'm putting it out in the simplest terms because I am very open to any kind of amendment, as you stated, and working with any party to amend this in order to get the right balance and the right specificity down. Because again, this is not about 99.99% of the organizations getting current use in our state. It's really, as far as I can tell, only 2 organizations that are potentially damaging our ecosystems and are receiving massive tax credits for doing so.
Thank you.
Representative Lang.
Thank you, Representative Lang. So in another hat, as Representative Reed knows, I'm also the chairman of Fish and Game. So my question is around the conversation of harboring non-native and non-domesticated animals. And as we had that naming the trout bill, and we found out there are basically no more native trout in New Hampshire, that we've, through our stocking policies, have basically overridden a lot of our native trout. And also around Fish and Game stocking a pheasant, which is not a non-native animal. My concern is, could we be sweeping in some farms that allow Fish and Game to stock their brooks and trouts as well as their fields with the pheasant when they do their restocking? Will those farms now have to give up their current use rights?
Well, that's certainly not my intention, and thank you very much, my chair. But again, I'm very open to any kind of language that would get down to that specificity if we think that might be an issue. I am specifically talking about organizations that get the current use credit specifically for the kind of bubble nature of bringing in exotic species. So once again, not trying to impact 99.99% of the organizations that do, including the people who are just getting current use and are allowing the Fish and Game Department themselves to stock species that won't become invasive.
Thank you. Representative McDonald has a question. Okay.
Thank you.
Representative McDonald waves off. Representative Davis.
Thank you, Mr. Chair, and thank you, Representative Reed, for taking my question. Following up on the previous question from your chair, I wonder if you would be amenable to an amendment to the language that specifically cited tax exemptions for private hunting clubs. It seems to me that that would solve it.
Yes, I'm open to any amendment that gets to the aforementioned purposes of my bill. As I've said repeatedly, it's this very, very specific problem. So anyone who can offer language that gets to that in a way that upsets the least number of people, I'm very much behind.
Okay, seeing no additional questions for Representative Reed, I'm going to move on to our next testimony from Representative Rum from Maryland. Is she on the line?
Yes. Good morning. Can everyone hear me?
Yes, go right ahead.
Oh, thank you very much, Mr. Chairman. And thank you to the members of the County Municipal Government Committee. I come before you to speak in support of HB 467, I'm sorry. And I submitted my written testimony very early this morning, so you should have that. As ones who love New Hampshire and all that makes our state special, I'm sure that you join me in appreciating this bill. It reflects on the intent of our state's current use statute to preserve the natural and traditional land use in the Granite State. However, the New Hampshire Advantage fundamentally relies on assessing non-current use property to raise tax revenue to fund local services, including public education. We have been successful since current use passed into law in 1973 in balancing lower revenues from land in current use with regular tax rates for other properties. But it is consistent with current use when land is used to, but it is not consistent with current use when land is used to introduce non-native, non-domesticated animals for private paid recreational hunting. Is the legislative intent for wealthy out-of-state hunters to stock private land, public use forbidden, with non-native species and pay handsomely to hunt them? Is it worth the risk of destroying the habitat of our native species? Is that the New Hampshire way? I don't think so. I believe that the current use statute needs to clarify that its intent is to protect the natural and cultural heritage of New Hampshire. That is what this bill does, and I respectfully ask that you recommend ought to pass. Thank you. And also, there's a couple things that came to mind as Representative Reed was speaking. One is that she's referred to Corbin Park, but currently it's being referred to as the Blue Mountain Forest and Game Preserve. So if you are doing your own research or background on this, you will find that name comes up quite a bit. There's a person who actually has logged in an entire history of the Blue Mountain Forest and Game Preserve from back in the day when it was established by Austin Corbin. It's under a website called it's mayette.us/Corbin Park. It's MEYETTE.us/Corbin Park. You will find a wealth of information there on this. Much of it is anecdotal, so I didn't want to repeat it, but if you want to get an overall sense, then that would be a good place to go to. I also want to address a couple other comments that were raised by this committee during Representative Reed's testimony. One is regarding the non-native trout. Yes, the non-native trout have pretty much replaced our native trout, but they are contained within a lake or a water body. So unlike land where non-native species can expand and there's just really no boundary, invasive species in a water body can be controlled. I know that we've had serious issues in New Hampshire lakes and rivers with not invasive species of the plant species. And even then, it can still be controlled to some extent. We work very, very hard to control those species. And the danger is we can get to a point where we're just running in place, that we may not eradicate them, but we can manage them. And I know with the situation with wild boar that have escaped, they go in and do a lot of crop damage of farms. They also displace some of the food that native animals need. And I believe Representative Reed spoke about the disease that can be spread from elk to white-tailed deer. So I just want to bring that up. I've served on the Aquatic Invasive Species Commission, so I've learned a lot about the risk and threat that are posed when we allow non-native species to enter our ecosystem. And that being said, I would be very happy to take any questions.
Representative Mangiaputo, you have a question for Representative Rung?
Thank you, Mr. Chair. Thank you, Representative Rung, for taking my question. You spoke about, both Representative Reed and you spoke about a specific large blue forest in game preserve, 26,000 acres of land. Are there any other that you know of in our state that may not be this large, but they are coming in small areas to kind of take over. And my second question is in terms of ticks and other parasites that live on animal body, how does non-native animals carry some of those kind of parasites on them that can spread diseases not only to the animals and the environment, but also to the human, because they bring new kind of parasite, like the Lyme disease, for example, that is native, but are there other ones that can bring? Thank you.
Thank you, Representative Mangiaputi, for your question. For the first question, no, I'm not aware of any other hunting clubs or preserves that are being formed. I first heard about Corbin Park a few years ago, and my first question is, why are they under current use? Because it's not a current use when we look back at our natural and cultural heritage of New Hampshire, to have exotic hunting clubs, especially ones that take up 26,000 acres. To me, my biggest issue with the situation, and it's not just, it could be anybody, it's just that using current use laws to reflect the intent of the state, the lawmakers that drafted it, and our government. I mean, when we go through New Hampshire and we look at tracts of land that are in current use, it's a beautiful thing. It's a beautiful thing to see the forests where people are allowed to hike through. They're allowed to go in and hunt, and they hunt native animals. But when you have such a large tract like the Blue Mountain Forest and Game Preserve, also known as Corbin Park, where the public is strictly not allowed to go on. And if they did, they're not hunting our native species. They're hunting wild boar, elk, bison. Actually, that Corbin Park used to be the largest, had the largest herd of bison in the east of the Mississippi at one point. It's a club. There's a lot of money involved, but as Representative Reed said, it's very secretive about what their finances is. But in totality of looking of all of that, it doesn't seem consistent with the intent of current use. And my argument is, then why is it allowed to be in current use?
Okay.
Oh, and I'm sorry, your second question, sorry, Representative Management. No, I'm not aware of it, but what I know of, in generally speaking, of exotic species, that over time they do cause a lot of damage. We see it particularly now with insects, non-native insects coming in and destroying tracts of timber. There was one species that was a real problem for New Hampshire before COVID, where we had to really restrict people bringing in firewood from out of state. So it's protecting our state against non-invasive species is a lot of work. We have to be diligent all the time. But thank you for your questions.
Next question is from Representative Lang.
Thank you for taking my question. I guess my question is, it said, I believe you served on a current use commission of some sort. And my conversation with the Fish and Game executive director recently, I learned that there were 3 million acres in New Hampshire under current use, but only 1.5 actually allow recreational access. Is that consistent with what you know?
Thank you for the question, Representative Lang. The commission I'm on was actually the Aquatic Invasive Species Commission. I'm not on the current use commission. But as far as your question goes, I think a lot of the land that is in current use is pretty inaccessible. It's in the Great North Woods. But I do know when you look at our snowmobile clubs, people are allowed to cross on private property to travel through to get to another trail. I learned a lot about that last year. I was on Resources Committee and we studied a lot about Jericho State Park up in Berlin. You know, there are uses when we look back on what New Hampshire is and why we love New Hampshire. when we look at current use, those are uses that make our state a better state. It preserves what's important to New Hampshire and what makes New Hampshire unique. When I look at people using current use for exotic animals hunting, and trust me, I support hunting 100%, but it's almost turning a big swath of current use into safari-like, where we're hunting animals that would never be found naturally in New Hampshire. Is that an appropriate use to be under current use? In my opinion, it is not.
Okay, the next question is from Representative Davis.
Thank you, Mr. Chair, and thank you, Representative Reed, for taking yet another question from me. I look at this bill almost as trying to put the left-handed glove on the right hand. It seems to me that the real issue here is that this private club is exempt from taxation. Not, you know, the invasive non-native species argument. You know, starlings are invasive species. Emus and llamas are non-native to New Hampshire. I just don't know where that argument begins or ends. But it does seem to me that the nub of it is the tax status of this private club. Am I incorrect in that?
Oh, thank you for the question, Representative Davis. I think the key word here is domesticated. When we look at emu, llama farms in New Hampshire, I think there's a couple llama farms in Hillsborough County that I'm aware of. They're domesticated. They're being used for agricultural business, and that's consistent with New Hampshire. They're not exotic in the fact that they're allowed to roam freely to invade on an ecosystem of native species. So I think that's the key differential point with this bill, is that we're talking about exotic species being introduced and, for all intents and purposes, just having free reign over our natural ecosystems. Representative Reed spoke about the 26-mile fence. Well, that fence is not maintained very well. It's very common for especially wild boar to escape. And now they're starting to breed outside of that preserve. So when you look at farms or agricultural facilities that are raising animals that are not native to New Hampshire, that's essentially more of a farm. They're contained, they're being raised for a purpose, they're domesticated. So I think that's the main point. And that, to me, that domestication, agricultural business is very consistent with the spirit of current use.
Right, our next speaker is going to be Representative Mason. Just to cue him up, but we have additional questions from the committee from Representative Trelevin. And who is your question for?
I'm all set.
Okay.
I've had my question answered. Thank you, Mr. Chair.
All right, I want to next recognize Representative Mason, who'd like to speak against the bill.
Thank you, Mr. Chair and committee. I'm in opposition to House Bill 467, and I ask you to motion to ITL this bill. New Hampshire current land use was really developed in 1973 by the General Court, and the spirit of the law is to save New Hampshire's open space by allowing private landowners an affordable tax base for rural land usage. It's been established and a long proven track record of success in our state. Current use tax strategy works congruently, maintaining open land while reducing urban sprawl, resulting in protecting our privately owned forest, agricultural lands, wetlands, and wildlife habitat. Additional incentives are allowed for forestry stewardship programs, thus creating enhanced timber yield and quality. At harvest time, this results in timber tax revenue. It also plays a significant role in providing views and vistas, creating a kaleidoscope of charm and charisma that attracts tourists to our state of New Hampshire. It successfully adds private land use trespass, giving opportunity for recreational hikers, skiers, cyclists, water recreation, and ATV snowmobilers, bird watchers, to name a few. Landowners have the right to keep their land closed by paying a higher tax rate. The current use program creates far more tax revenue and burden, as open land has few and needs few services. The tax incentive for these property owners helps keep their private land open and intact. Since established, the program has protected an estimated half of our 5.74 million acres, and further estimates half of this land is left open to public recreation. So the other half is closed. Our current use land program has been examined and stood the test of time, rightfully protecting as legislature continues to make the right choices and shelter the established current program. As proposed, the amendment inclusion, nor shall open space include any farmland, forest land used to harbor non-native, non-domestic animal species. This opens a very large Pandora's box and jeopardizes many of our citizens whose open space commitment in the spirit of the law. Places like Corbin Park, 26,000 acre preserve, established in 1890, maintains many non-native species as well, and would force an end to their current use status. The park managed for 130 years a population of non-native wildlife, recreation, hunting, harvesting by its owners and guests. Corbin Park open space land practices wildlife and forestry management along with wetland protection, creating habitat for both non-native and native wildlife. Corbin Park has worked with New Hampshire foresters and loggers, creating jobs, tax revenue, and timber tax. The forest releases result in additional habitat, natural feed for both native and non-native species. The park maintains that its current use status is well within the spirit of the law and is no different than someone using recreational land at home for cross-country skiing on their own private land. Corbin may survive this incurred legislation tax burden of House Bill 486, but at the same time, House Bill 467 would have unilateral devastating impact on many New Hampshire landowners. New Hampshire has additional upland preserves, non-native upland game bird species regulated by New Hampshire Fish and Game licensing that would be affected. It promotes similar land management practices, maintaining excellent habitat for both native and non-native species. These preserves are membership-based with family focus and open to the public. These provide countless hours of outdoor experiences for many New Hampshire families that draw from in-state and out-of-state sportsmen alike. The preserves offer a wide range of experiences and work hand in hand with clubs and groups and provide a safe, non-crowded environment for recreational shooters, hunters, and dog trainers alike. In addition, in New Hampshire Fish and Game, currently 21 licensed non-native species game propagation growers are in New Hampshire, many of whom would be forced to forfeit their current land use or give up their passion. New Hampshire sport dog owners and trainers use current land use throughout the state and often trained with live birds. Some of these dogs are used for field trial competitions throughout the United States and abroad. New Hampshire Fish and Game stocks pheasants on 13 privately regulated shooting areas. These landowners, to retain their current use tax credit, would be forced to close their land to public use, ending the cooperation and use of New Hampshire Fish and Game, jeopardizing the pheasant program. Furthermore, there's countless additional non-native species that habitat in Seek Harbor. Examples: the rock pigeon, the starling, house finch, brown trout, rainbow trout. State pigeon club exists that use homing flight pens, release on the current land use. Farms have large flocks of these birds that seek winter harbor and feed off their crop residue. Private stocking ponds purchased and raised both rainbow and brown trout. As written, this language would end the current use as we know it. From personal experiences on my own farm in woodlands that I have in current land use, I've stocked my ponds, raised game birds, and trained dogs. I hunt at these New Hampshire public reserves and New Hampshire Fish and Game stock sites, purchasing state licenses as required. Under the amendment, I would no longer be able to raise game birds on my land unless I gave up the current land use benefit. Many others would feel the same financial strain, forcing the abandonment of their passions. Public hunting areas on private land would be lost or devastating blow for the New Hampshire Fish and Game Pheasant Hunting Program. This amendment language does not belong in our current land use program, and nor does it intend. Current use programs help us ensure that New Hampshire that we love will be preserved for generations to come. I ask you to vote ITL on this bill.
Representative Porter had a question for Representative Mason.
No, Mr. Chair, my hand is up by accident.
Okay, Representative Trelevin.
Thank you, Mr. Chair, and thank you, Mr. Mason, for coming and testifying before us. I'm wondering, you've mentioned current use several times and the fact that New Hampshire stocks some pheasants. I'm wondering what you think about 26,000 acres of land that is not open to the public in any way, shape, or form, and brings in exotic species that can escape into our quote unquote New Hampshire natural environment.
Representative, thank you for that question. 26,000 acres, there's actually 1.33 million acres of current land use that is not open in the state of New Hampshire to the general public. The landowner has the right to restrict it by paying a higher fee on his property tax. And the current land use, they do pay property tax. It's a reduced rate, so the land can stay open and it can be used for services. Farmers couldn't afford to farm the land at the same tax rate that a house is taxed at. And their homes, those that are familiar with current land use, your home site and that it's broken off, the areas around your home, you pay a full tax rate for that property. Okay, you get the break on the back land, the land that's used for timber management, the land that's used for just swampland in New Hampshire. We've got a lot of wetland in New Hampshire. So those tax breaks are current there. If you've ever have had chance to go up and see the properties at Corbin Park, a lot of it's just the side of a mountain. It's very rugged land, a lot of it. There's a lot of vistas and views. We've seen people pull land out of current land use. They pay a penalty for that when it comes out, when they develop it. So this tax break, current land use has worked well to keep New Hampshire's scenic. And if we start to meddle with it, we're going to lose that scenic look that we all so much love New Hampshire for.
Follow up, Mr. Chair?
Yes, go ahead.
Thank you. Mr. Mason, could you tell me where I could take a look at the information you just shared with me about the 1.3 million acres of land?
You can Google that. You can Google that quite easily.
Thank you.
With estimates in New Hampshire current land use.
Great. Thanks very much. I will.
Representative Mangiapudi had an additional question.
Yes. Thank you, Mr. Chair. Thank you, Representative Mason, for taking my question. I have two questions. One is, you talked about this being part of a mountains side. Does this we also have the view tax in New Hampshire where, the owners pay additional taxes if I have a good view of the mountain or lake and I can't put things up like solar array. Can that be imposed on this current land use? And my second part is, there was a disease, which Dutch elm disease, that destroyed or killed all our elm trees. And it didn't take too long for that to happen. And to bring those Dutch elms back.
Representative Mangiapudi, just hold on for a second. A point of order that's being requested.
Yeah. So I'm asking about the question in terms of the tax, land use.
Hold on a second, please. Hold on. Point of order?
Yes, Mr. Chair, we're well behind. We're almost 12:30, 2 hours behind here.
I'd like to move things or speed things up a little bit. Number of questions, those kind of questions can be discussed possibly during our executive session.
Okay, I understand the point you're making. So let me just express to the committee to be brief in your questions and make sure that the questions.
She's categorized, but I
Where
think
these questions
the bag isn't filling and there's.
Also, please go on mute if you're not recognized to speak. Representative Mangiaputi, please continue.
So my question is to Representative Mason in terms of how long, are you aware of the fact that we lost elm trees for Dutch elm disease from the beetle that came outside? It was an invasive beetle and it's taking much longer. So this could affect, if we don't take notice right now, this could affect our natural beauty in New Hampshire. And isn't that our responsibility to be the stewards of saving our New Hampshire natural beauty?
Well, I thank you, Representative. I think I understand your question. It is our duty to police a lot of invasive species. Invasive species, though, the Dutch elm disease that you speak about, that happened back when I was a kid about 60 years ago. And one of the bigger ones probably right now is the beetle that came into Massachusetts and started this spread, and we've shut down a lot of border lines with timber being able to cross state lines and issues like that. We do a lot of preventative things to do that. APHIS comes in. APHIS is Animal Plant Health federal programs, and they come in and they'll take over some of those programs to make sure things are handled properly like with that. But these animals are really an ecofusion animal. They've been here for a long time. These species didn't come in last week into New Hampshire that we see inside Corbin Park. The pheasant has been here a long time. The pigeon has been here a long time. They're all species that have come in. Now, I can tell you point blank from pigeons, as raising animals, I have had animals be condemned because of avian TB. So does that mean we do away with all the pigeons that are in the state of New Hampshire? But I have lost revenue and income on my farm because I've had to do away with animals. So this becomes a very complicated question. And I don't think there are many of us qualified to really answer it. I don't know how else to answer that for you, but that's
Thank you, Representative Mason. I'm next going to go to Tara Guitar. Are you in the queue?
Yes, Mr. Chair, I just have to get there. There we go. Okay, should be all set to go.
Guitar, you are from the New Hampshire Wildlife Federation. You want to speak in opposition to legislation, and you've asked for 2 minutes. I'm going to hold you.
Okay, perfect. Thank you. My name is Tara Gattau. I'm the Executive Director for the New Hampshire Wildlife Federation. The mission of the New Hampshire Wildlife Federation is to be the leading advocate for the promotion and protection of hunting, fishing, and trapping, as well as the conservation of and access to fish and wildlife habitat. With an affiliated membership of over 48,000, the New Hampshire Wildlife Federation represents the interests of members from across the state. The New Hampshire Wildlife Federation would ask you to oppose House Bill 467 and any attempts to target specific properties currently eligible for current use. The New Hampshire is home to multiple shooting and hunting preserves, which would all likely go out of business if this bill were to become law. These preserves operate on large tracts of pristine and undeveloped land, which are maintained and protected to maximize wildlife habitat. If these properties were no longer eligible for current use status, the owners would likely need to sell the land, putting large amount of protected land at risk of development and permanent loss. Hunting preserves in New Hampshire are a source of revenue for the state. These facilities bring in tourists and often host events which generate revenue for New Hampshire. These properties also bring out state tourists into more rural areas in New Hampshire, which benefit other local businesses. For this reason above, New Hampshire Wildlife Federation asks you to vote House Bill 467 ITL. Thank you.
Thank you. Are there any questions for the speaker? Seeing none, I'm going to now move on to Robert Johnson from the New Hampshire Farm Bureau Federation. Representative Reg, you right?
Thank you, Mr. Chairman. Can you hear me?
Yeah, you've asked for 3 minutes. I'm going to ask you to stick to 2.
Okay. Thank you, Mr. Chair and members of the committee. For the record, my name is Rob Johnson. I represent the New Hampshire Farm Bureau as the Federation's policy director. Farm Bureau is a federation of New Hampshire's 10 county Farm Bureau organizations. We consist of membership of just under 2,000 family farms and a little over 1,000 other supporting members. Current use land assessment is the foundation of our state's working farms and forest. I want to stress that there is no program more important to New Hampshire agriculture. We oppose any efforts that deviate from the founding principle of current use and oppose using the current use law to address other objectives, which this bill does. Please do not go down this road. We ask you to keep current use the focused open space program that it is. And in closing, I'd just like to speak to the specific language that's proposed. Our concern is that current use landowners harboring non-native, non-domesticated species of no control or fault of their own, and some others that have not been mentioned, we're talking gypsy moss, emerald ash borer, could be forced to lose their current use assessments. Fish and Game already requires and has authority over non-native, already regulates and has authority over non-native, non-domesticated species. Thank you for your time and consideration.
Thank you for your testimony. Are there any questions for Mr. Johnson? Seeing that, I'm going to move on to our next speaker, Joseph Mullen. He's from the Congressional Sportsmen's Foundation. You've asked for 3 minutes. I'm going to give you 2.
Thank you, Mr. Chairman. Can you hear me okay?
Go right ahead.
Perfect. Thank you. My name is Joe Mullen. I'm from Grafton, Massachusetts, and I'm the Northeastern States Assistant Manager for the Congressional Sportsmen's Foundation, the 501c3 nonprofit I represent today. I would like to express our opposition to House Bill 467. I've also submitted testimony to the committee, so for right now, I'd like to touch upon some of the high-level points with my time. Several hunting preserves, sporting dog kennels receive incentives under the current use tax assessment by conserving the land, water, forest, agriculture, and wildlife resources on their properties. Because these operations use non-native species, under House Bill 467, they would become ineligible to receive the open space land benefits. And it's not unreasonable to surmise that some of these locations may look to commercialize or develop their land. National participation in hunting has been on a general decline, and shooting preserves offer new sportsmen and women with the ideal opportunity to experience time of field in a learning environment. Additionally, on these properties, hunters will often spend time on the site's shooting range, which, in conjunction with shots taken in the pursuit of game, reflects contributions made to the American system of conservation funding, a user pays public benefits structure under which those who consumptively use the resources pay for the privilege and oftentimes the right to do so. In 2020 alone, New Hampshire's sportsmen and women generated around $18 million for conservation through the system, part of which includes excise taxes on sporting related goods such as ammunition. Another consideration I'd like to provide is the effect that this bill would have on sporting dog kennels. These kennels offer true conditions for sportsmen and women to train their dogs. Many kennels use non-native species in their programs. Speaking from experience, my black lab trains over birds that are non-native. So I know I'm short on time here. With this in mind, if not all hunting preserves and sporting dog kennels use non-native species, such as pheasant and Hungarian partridges. And despite these game birds being a staple pursuit in the upland hunting community, their existence in North America by virtue makes them non-native and non-domesticated. Once again, I'd like to thank you for your time and reiterate my opposition to House Bill 467. Thank you.
Thank you, Mr. Mullin. Are there any questions from the committee for Mr. Mullin? Seeing none, the next speaker will be Jason Stock from the New Hampshire Timberland Owners Association. Got 2 minutes for you, Mr. Stock.
Good afternoon. Can you hear me?
Yes.
Okay. Thank you. And thank you for the opportunity to testify. For the record, my name is Jason Stock. I'm the Executive Director of the New Hampshire Timberland Owners Association. We have about 1,300 members who own and manage over 1 million acres of land, and most, if not all of that, is in current use. And what's important to note is that these landowners, everyone has a different management objective. There are landowners that manage, or their objectives include recreation, which could include hunting, hiking, bird watching, and of course, forest products, as well as just owning land for the sake of owning land for its natural beauty. But as Mr. Johnson had mentioned, that current use is really a fundamental underpinning to private timberland ownership in the state. And the last clause in the purpose or the declaration of the law, and I appreciate the sponsors reading the first portion, but the last portion is just as important, and that is, it shall encourage but not require management practices on open space lands under current use assessment. In other words, current use is blind to how the land is going to be managed. It's a very simple law, and that's one of the beauties of this law, is that it looks simply at, is it developed or is it open? It doesn't, and based on that, that will determine whether you are eligible. It doesn't get into, are you growing corn versus trees? Are you managing for wildlife versus managing for timber? So that's one of the beauties of the law, and it's one of the things that makes New Hampshire's, I would argue, one of the best open space laws and policies in the nation. There was talk earlier about, that it's a tax break, and I always bristle a little bit because it's not really a tax break. What it is it's an assessment of the land on its ability to grow a farm product or a timber product. It is a different way of assessing land, as opposed to, say, growing single-family homes, growing commercial development. It is an assessment on it. And in fact,
Mr. Stock, this is the chair. Can I ask you to try to wrap?
Yep, and I'll just thank you. The benefits. I just want to also mention that there was talk about benefits. Their current use land is eligible. You can post it, but even posted land provides benefits such as scenic abilities, clean air, clean water, etc. And I would argue that that holds true to Corbin Park. It is clear this bill was introduced targeting a specific landowner because someone does not agree with what they're managing for. And for that reason, I urge you to vote this bill inexpedient to legislate. I'd be happy to answer any questions, and I appreciate your time this afternoon. Thank you.
Are there any questions for Mr. Stock from the committee? Seeing none, the next speaker I'm going to call on is a member of the public, Scott, I believe it's Rollo, who's in opposition. Is he in queue, Representative Mangiuri?
Try that one more time. Sorry about that. Yes, and ready to go.
Okay, Mr. Rollo, the floor is going to be yours. You've asked for 2 minutes. You got it.
Thank you, Mr. Chairman, and thank you, honorable members of the committee. My name is Scott Rouleau. I live in Hillsborough, New Hampshire. I'm the owner of Farview Farm and New England Upland LLC. I'm also the president of the New England chapter of Pheasants Forever, which is a conservation group focused on the improvement of pollinator and upland habitat for all species, including native and non-game birds, as well as small game. Farview Farm is a mixed-use property. We have hay fields, grow buckwheat, sorghum, corn, have wetlands, a pond, a brook running through it, which the state stocks with trout. We also keep bees for pollination, honey, and their wax, and are licensed by New Hampshire Fish and Game to keep pheasants for dog training, hunting, and ultimately table fare. Our property is less than 400 acres, and we are mostly in current use. I'm opposed to this particular bill primarily because of the language being as vague as it is related to the species that we keep. Pheasants have been talked quite a bit regarding this particular bill from some of the earlier folks that discussed it. And given that the state releases these birds on many other landowners' land, and the fact that these birds are not raised in the wild, they're actually raised in captivity, one could assume that they were domestic. We have a business that's open to the public. We're not private like Corbin Park. As some of the other people their testimony stated, we have many, many users of our facility throughout the state of New Hampshire. And if we were to lose our current use status, our business would be in jeopardy of going under. So based on that, we certainly are opposed to this particular bill.
Thank you. Any questions for Mr. Keene before we move on? Seeing none.
You mean Mr. Lowe?
Rollo.
I'm sorry?
Rollo.
Oh, sorry, Rollo. Next speaker is going to be Mr. Keene. Ahead of myself a little bit. Who wants to speak in opposition to the bill? You've asked for 5 minutes. I can give you 3.
Should be good.
Mr. Keene, are you with us? Representative Mangieri, you see him in queue?
He is in queue and he is unmuted right now.
Mr. Keene, you want to speak in opposition to the bill? I give you 3 minutes. And you are from Sunapee, New Hampshire.
He now has his hand up. I've recognized him.
Maybe he needs to unmute himself?
I'm going to promote him to panelist and see if that works.
All right, Mr. Can you
hear me now?
Yes, we can hear you very well. I can give you 3 minutes.
Sorry. I don't know what. You think I'd have figured it out this deep into the pandemic? I will be very succinct, Mr. Chairman and members of the committee. I'm opposed to HB 467. I am a citizen of Sunapee, New Hampshire, but I am also the Senior Vice President and General Counsel for the National Shooting Sports Foundation, which is the firearms, ammunition, hunting, and shooting sports industries trade association. Our members include companies such as 6 Hour Ruger and many, many firearms retailers throughout the United States, and including Farview Farms, which you just heard from Mr. Rulo. This legislation is clearly aimed, if you pardon the pun, at Corbin Park. Much of the discussion has been about issues surrounding wild boar escaping from the property. This legislation does not really truly address the purported issue it's trying to solve. I view this as anti-hunting legislation that will hurt shooting preserves like Mr. Rulo's that he just described and reduce access and opportunity. The purpose of the fair use is to promote conservation. And so by doing away with this credit, you will be hurting conservation because, as Mr. Rulo explained, he would likely have to go out of business. It would also impact animal agriculture, such as, for example, Yankee Farmer in Warner, which raises buffalo for sale in the state. And that is obviously a non-native, non-domesticated animal. And I would also point out that elk are, in fact, native to New Hampshire. While obviously they are not in any great numbers in the wild, they are not a non-native species. So that is incorrect information. Much of what we heard earlier is simply not factually correct. If you want to address an issue of wild boar, it should be taken up by the Fish and Game Commission, not by this committee, which will hurt farmers in small game preserves, in kennels, and in hunting dog training locations. So I thank you for your time, and I ask you to oppose this legislation.
Any members of the committee have a question for Mr. Keene? Seeing none, our last speaker on this bill is Donald McFarland, a member of the public.
I am looking, Mr. Chair. Oh, yep.
He's from Orange, New Hampshire.
My video
Should be good.
Can you promote me to panelist?
I can.
Mr. McFarland, you've asked for 3 minutes. I'd like you to try to get to your points in 2.
Okay, I just got rejoined. I missed what you just said, Mr. Chairman. Can you repeat that?
You've asked for 3 minutes of speak. I'd like you to try to get to your key points in 2.
I will endeavor to do so. And I think a number of the points that I wanted to speak on have already been covered. So we'll see what I can do. Just to cover where we are, that I think some of these things have already been discussed. Representative Reed indicated that her language is simple, and yet she acknowledged up front that she knew that there are clear weaknesses with her wording. If we can't find simple language that will suffice, I have very little confidence that making the language more complex will make the legal interpretations upon this clearer. Domestication is by no means a binary, a black or white definition. It is a continuum, and it is a rather subjective one at that. We have a number of definitions. If you just go and Google domestication, you can find many for yourself, which make it clear how complex that definition is. Representative Manjapudi asked about the definition of native versus non-native species of animal. I put it to you that, you know, she is very much right to question what constitutes a native and domesticated species. I dare say I qualify as non-native to New Hampshire, for that matter to the continent, although it's not clear from the bill, are we talking about New Hampshire or the US or America? My wife and I were talking recently about the possibility of purchasing some Highland cows for our farm. And even although we'd be doing it from stock that was grown here in this nation, it would not be from this state, and it would not be any that have as provenance and historical a relationship to New Hampshire as the New Hampshire elk and wild boar in Corbin Park. And from time to time, for that matter, my wife has suggested that I may not be wholly domesticated. So should my farm and forest land be removed from current use because of myself? It's absurd, and I think we've addressed that. But I think as you look as a committee at changing the language, which clearly you would need to do if this were to be passed, I suspect that there is very little language that you might find that would not have other issues as well. Moving on, the purpose of current use, I think Mr. Mason addressed fairly well, so I won't spend much time on that, other than to say that the question that was first posed by Representative Treleaven and a good deal of the additional commentary that followed therefrom seems to imply that current use is about having the land be open to the general public. It is about what are we getting from it, that we're not getting anything from it was discussed several times. That was never the intent, nor the stated purpose of the current use laws as and when they were enacted, or as and when they've been revisited and modified many times over the years. We, the people of New Hampshire, just decided when we passed RSA 79A that it was in our interest to tell people precisely what and what not to do with their land? No, I don't think so. What in fact happened was that we determined it was in the public interest to encourage the preservation of open space. And if you read the statute, you will see that stated very clearly there, better than I can do it right now. 26,000 acres of open space with a handful of structures on it, and with careful and well-funded management of the flora and fauna thereon, is precisely the sort of purpose that was contemplated when we passed the current use laws here in this state. Our current use laws were instrumental in my making a decision to move to New Hampshire and to choose this as the state I wanted to live in and grow my family in, and to earn wages and pay taxes, both property taxes and other taxes within this great state. This is a slippery slope, And I'll move to the next point that I wanted to make, which is about the sponsor's intent. I read this bill last night by happen chance because I planned to come today, unfortunately not in person to the State House, but to testify on another matter. And I was horrified to see this because it struck me when I first read it as an attack against Corbin Park. If you wish to attack the Blue Mountain Forest Association, and you point out that they are already recognized explicitly by name in existing statutes, existing RSAs, then call them out by name. Representative Reed made no bones about it. This was her intent, to go after Corbin Park. And she's not too worried about the fact that there's maybe one other, in her view, club or park or whatever that could be included as well. If that's your intent, then put it in the bill. And if it was a bill that said so, if it was a bill that said this is about going after Corbin Park, I would regard that as obscene overreach by the sponsor. Were this a socialist state, I should not be surprised to see such spitefulness against citizens who have done well for themselves and attained some measure of wealth and enjoyment. That was a significant reason for my emigrating from the United Kingdom and coming to this fair land, and I'm appalled to see what is being done here by the sponsors of this bill and those who would support it. I have two small points left that I will wrap up as soon as I can, Mr. Chairman. The first is that this is not a novelty. We have had many prior bills intended to attack Corbin Park. A number of recent bills even. We had a bill just last year that attempted to impose a safari hunting license, House Bill 1573. If you're going to make an argument that we're not getting enough funds in to take account of wild boars that escape and which frankly are quite satisfactorily hunted by the neighbors of that park today without incurring substantial costs. But nevertheless, if we believe there are costs there to address, then at least House Bill 1573 addressed it by bringing funds in for the Fish and Game Department. It didn't attempt to say, let's assume that Corbin Park is about growing school children and growing residential waste and requiring snow plowing of their property and requires huge increases in local taxation for them. The purposes here are not even slightly aligned. The final point that I will make is about the fiscal impact. And I note that there was no fiscal note on this bill. Will we add a fiscal note to reflect the likelihood of litigation and to reflect the possible need to compensate people for this, what amounts to a taking of land and of enjoyment? In conclusion, I've never set foot in Corbin Park, and yet it gives me great satisfaction to know that those 26,000 acres of open space have been and are being preserved with well-funded management practices, and to know that we have a place in New Hampshire where we allow the majestic, and I might add tasty, New Hampshire elk and wild boar to roam. Please vote inexpedient to legislate on this bill. Thank you.
Thank you, Mr. McFarland. Next, we have a member of the public, Nancy Holmes, who would like to speak. I'd ask you to please state where you're from and whether you support or oppose the bill.
Hi, my name is Nancy Holmes. I did sign in as opposed to the bill. I've been listening along to all the testimony. I'm here from New Boston today. I'm not a hunter. I am in favor of keeping as much land in New Hampshire open as possible because I love it. But I want to correct a couple of things that I've heard stated as facts, which I'm pretty sure are not facts. You've all heard plenty about how the fact that current use is not a synonym for public access, so you know that. But another statement that was made is that the buffalo that are sitting on our farmers' lands in the state are domesticated, tame animals. They are not. Just because an animal is being kept in captivity, that does not make it tame. If keeping it in captivity did make it tame, that would mean all the animals on Corbin Park would, of course, be domesticated animals. And I don't think that's exactly what anybody means to say. The AKC hunt clubs are another big group that are going to be impacted if this bill goes through. And this is not a bunch of rich people coming in from out of state. This is all your local guys who want to train their dogs. And excuse me, your local ladies too, because I know several ladies who do. Corbin Park has been in place since 1890, as far as I can tell. And that means for 130 so years, this park has been in place without any devastating impact on the environment. I do believe that the instance where, and I'm sorry, I'm old. For me, they were Russian wild boar, not Eurasian. But the Russian wild boar, I believe their escape and as breeding colony into southwestern New Hampshire came about during a hurricane in the 1930s. So there may be some newer escapes that I just haven't heard about in the paper, but there is a situation in the southwestern part of the state where there are wild boar reproducing, as far as I know, not on the game preserve and have been for a long time. That would mean that everybody whose land they are on would suddenly lose current use under this bill. So would the people who farm emus, ostriches, buffalo, red deer, and the way it's written, it's so vague that it would include the people who are raising hedgehogs and soft-furred African rats that they breed for use in feeding snakes. And oh, God help the poor people who are raising boa constrictors. This bill is really bad. I really believe it needs to be ITL'd. And when I looked at this bill, and after listening to everybody today, what I came down to is that this park probably uses local food for animals and people. It's a tourism destination. It is not a non-producing area in the state. And what I'm hearing from the sponsors, the people who are for this bill, is how dare those rich people be invited into our state by a club they belong to in order to be tourists here and practice in what they choose to do as a tourist, which is hunting on a private preserve. This kind of discrimination is terrible. So yes, I'm just going to say, I think you should ITL this bill.
Thank you, Ms. Holmes. Our next speaker is from the public, Jake McGuigan.
Mr. Chair, I just need to let you know that my husband has come home for his New England lunch.
Thank you for letting us know.
Chair Dolan.
You on the line?
Yes, sir, Chair. I appreciate it.
I would ask you, see if you could limit your comments to 2 minutes.
It'll be 1 minute.
Please tell me where you're from and whether you oppose or support the bill.
Sure. Jake McGuigan, Managing Director of State Affairs for the National Shooting Sports Foundation. You heard earlier from Mr. Larry Keene, who is a resident of New Hampshire. Again, we represent manufacturers, preserves, retailers throughout New Hampshire and throughout the country. I just, again, want to echo the sentiments. I had sent written opposition to 467 in earlier today to the committee. I want to echo the sentiments of the New Hampshire Wildlife Federation, New Hampshire Farm Bureau, Scott, and then also New England Upland, who is a member of ours as well. Again, just so you remember, and it has been pointed out, sportsmen are the largest conservationists in the country and in New Hampshire. These people that do come into your state, they are spending money. They have a large economic impact, not just at Corbin Park, but in the various preserves around New Hampshire. So again, we ask you to oppose HB 467, and thank you for the time today. Appreciate it.
Thank you, Mr. McGuigan. Lastly, we have a member from the public who would like to testify, Peter Kroll. Peter, please tell us where you're from and whether you support or oppose the bill.
Yeah, this is Peter Kroll. I'm from Springfield, New Hampshire. I'm the president of Corbin Park, and I am absolutely opposed to this bill. We are, a 25,000 acre land management company in the Upper Valley. We house, obviously, we have the boar and the fence to keep them in, but we have a lot of members. Most of our members are from New Hampshire. Most of our guests are from New Hampshire, some from outside the state. And we maintain the property as a big preserve. It's a large piece of land that's undeveloped in the center of the state, and a bill like this could force its development. So anyway, I'd like to thank you all, and I hope that you vote this inexpedient to legislate.
Thank you. Thank you for your testimony.
Thank you.
At this point, having no additional comments in queue, I'm going to recess the hearing, rather conclude the hearing on HB 467, and we're going to take a recess for lunch, and we will reconvene at 1:20 p.m. and we will take up HB 486 at that point, and then 512 and 545 after that, and then we'll go right into executive session. So we'll be back from lunch at 1:20. Please be on time. Thank you. Yes. I know.
Mr. Chair. Mr. Chair, it's Representative Porter. Just want to remind you, we can hear when we can hear.
I have just muted the room. Thank you, Representative Porter.
Whose cat was meowing?
about something, or I'll say something, and they go, well, that's a terrible thing to say. And I go, oh, it's my Asperger's. Then they go,
Gentlemen, you're unmuted, the mics are live.
shh. Well, you know, you do watch the screen pretty closely.
I do, but today I didn't bring my computer, so I'm watching you on my phones.
My Chromebook ran out of juice. Says I had 15 minutes left, and I prefer not to run it down all the way to 0.
Mr. Chair, can you hear me? It's Jim Majori.
Yes, I just unmuted the room.
Outstanding. I'm just noticing that the prime sponsor is listed for our next bill on the list to speak, but I see only money as rep listed on our list of attendees. I'm going to make a guess that that's Representative Fellows, and run through that. And if I'm wrong, I guess we'll manage from there.
I have 3 people listed to speak. One is Tony Kaplan.
Yep.
Sally Fellows and Jeff McLinch.
Yes, I have that too, and I'll do my best to find them.
Sally Fellows is the prime sponsor.
Sally Fellows.
Yes.
And Tony Kaplan is not on yet, and Mick Lynch is not on yet. So this could be a quick one if the person listed just as REP is not Representative Fellows. We'll probably just need somebody to introduce the bill, but we'll take that up when we get there. Oh wait, no.
I can do that introduction if need be.
And I found Jeff McLynch.
What's the time? 2 minutes.
Where'd he go?
Thanks.
Tim, do you know of any efforts to give some sort of bonus compensation to National Guard members?
I do not. I don't think anything like that was in the latest stimulus package out of Washington, so I'm not familiar with them.
I just think that we owe those folks so much.
I agree. I went over and did the testing last Saturday before our session, and they were phenomenal. They ran an efficient shop. They took over the old Sears, and they did it like a drive-in. Literally, they rolled the doors up. They pulled 16 cars in. Bang, 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 bang. Opened up the other side. Let 16 cars out. Closed it. Opened it up. Let 16 more in. And it was like a factory. They did a great job.
My wife and I went to get our vaccination last Thursday after session at SNHU. The National Guard was running it. It was amazing. They had cars, all kinds of lines of cars, and it was like they had them all herded in different directions, and they hustled. They were pleasant. They were great. And you know, when you think about them, all they've done for us over the past year or so, my gosh.
Okay, you guys ready?
Yep.
Okay, this is the Municipal and County Government Committee here. on the 1st of March, 2021. We are entering the next hearing on the bill, House Bill 486.
Mr. Chair, I just have a quick question about the previous bill. Blue sheet, please. HB 467.
46 support and 41 opposed.
46 support, 41 opposed. Okay, and likewise on HB 486 that we're going to talk to now, we have 87 in support and 3 opposed. Okay, this is a bill that changes the low and moderate income property tax levels against the statewide education property taxes. So let's begin the testimony. The bill sponsor, Sally Fellows. Representative Fellows.
Yes, it is Representative Fellows. Is it possible to be promoted?
Yes. You're in support of the bill. You've asked for 10 minutes. Could I ask you to try to shave that a little bit?
Okay, I think I'm all set.
Okay, go right ahead.
So, thank you, Chairman Dolan and committee members. I'm Representative Sally Fellows. I represent Plymouth, Holderness, and Hebron, and I'm here to introduce HB 486. On Saturday, I emailed all of you my full testimony, as well as a spreadsheet of the payment history of this program. So today, I'm sure you'll appreciate that I will just go over the main points.
Thank you.
Low and moderate income homeowners property tax relief program is intended to help low-income people, many of whom are senior citizens, remain in their homes, but the program is in danger of disappearing. In the first year of the program, which was 18 years ago, 10% of New Hampshire homeowners applied and received a total of $7.5 million in rebates. Since then, participation has slowly decreased. Last year, just 1.5% received a total of less than $1 million. So one of the reasons for this decline in participation is the shrinking size of the rebate amount. In the beginning, the maximum rebate was almost $500, and that was 18 years ago. Last year, the maximum rebate was $183, and this year it will drop to about $160. And those amounts, I'll remind you, are just for the very lowest income level. Other people that do qualify would receive only 60, 40, or 20% of that maximum amount. So 20% of 160 is only $32. So you can understand why maybe some people are not applying for it anymore. Participation has also dropped because fewer people now have incomes that fall below the income caps that were set in 2002. The only people who get the maximum rebate rates now are single homeowners with an adjusted annual gross income below $12,500 or a 2 people or more household with an income below $25,000. So participation and rebate amounts will continue to drop unless we raise those income limits and the property cap value that is in the bill right now. It's set at $100,000 of property value for the rebate. This bill will increase the maximum rebate to about $350 for next year and make more people eligible. So I ask that you please help low-income people, particularly the seniors, remain in their homes by passing this bill. with this bill, they can once again get a meaningful property tax relief in the form of a rebate on their statewide education property tax bill. So I can take any of your questions. I would just add that compared to my testimony that I emailed you, I did include one additional piece of information today, and that was the part about 10% of the homeowners received rebates at the beginning, and only 1.5% are receiving them now. So I'm happy to take any questions.
Thank you. Representative Porter, you had a question?
Yes, Mr. Chair, just a brief one. Representative Fellows, this is the same bill, only modified with new numbers that you presented to this committee last year.
Representative Porter, that's correct. Both last time, it wasn't last year, it was actually 2 years ago.
Okay.
But what I did in both cases is I used census data to compare to the original program back in 2002 and updated them based on that. And I did the same process again. So it's the same bill as 2 years ago, although the caps in the amounts are higher now.
Thank you.
Senator Mangiapudi has a question.
Thank you, Mr. Chair. Thank you, Representative Fellows, for taking my question. How does this reflect our census data in terms of New Hampshire aging population? What was the census in 2002? And now in the last few years, we have become number 2 or number 3 in the aging population in the country, isn't it?
Thank you, Representative. I can't answer that question about the senior population, although with a specific number for you. But I do know that that is indeed the case, because we hear repeatedly on the news that New Hampshire has either the highest or the second highest percentage of senior citizens. The actual census data that I used is broken down by income category. So what I used to do the update.
Follow up, Mr. Chair?
Yes, go ahead with the follow up.
Thank you. This also shows that property taxes being the prime revenue for our state, this is a push and pull in terms of, do we raise, we are raising the property tax, but not getting the rebates. So that burden shift has happened. Isn't that true?
Thank you, Representative. I can tell you that that is going on in terms of property tax as a whole. This particular bill, though, deals only with the statewide education property tax. And that's been on tax bills for almost 20 years now. The amount, let me put it this way, the rate of that tax has gone down over the 20 years, but the property values have gone up. So when you have the same rate and property values go up, then the tax bill increases. When you have the rate going down and the property values going up in proportion, what you end up is the tax bill is actually about the same. So the statewide education property tax bills that people are getting now are about the same as they were 20 years ago, assuming you have, the same home and all that. One of the reasons this rebate is going down is because the home that was worth $100,000, let's suppose somebody had a home worth $100,000 20 years ago. Now it's worth $200,000, but they're only getting the rebate on half the property value and half of what they paid in, instead of getting the whole amount that they were 20 years ago.
Okay, next question we have is from Representative Pimentel.
Thank you, Mr. Chairman. Thank you, Representative Fellows, for answering our questions. So this is kind of new to me. So this is a program that it isn't a buy-in from the towns. This is actually a program with the state. Is that correct?
Yes, Representative, that's correct. This has nothing to do with local property rates or taxes, aside from the fact that it appears on your property tax bill. This is a property tax by the state. And the program started 20 years ago at the same time that, in response to the Claremont lawsuit, this was back when Governor Shaheen was governor. In response to that lawsuit, the state said that they would use a property tax to show a bigger share of state contribution to funding education. So that's when it appeared on the property tax bills. And what happens with that money is the local town clerks, tax collectors collect that money and they send it over to the school districts, and that becomes part of the adequacy aid money that is booked as being from the state.
Next, we have Representative Kaplan, who'd like to offer some testimony as well.
Mr. Chair, I cannot find Representative Kaplan in our list. I do see Jeff McLynch, but not Representative Kaplan yet.
Let's move to Mr. McLynch, who is in support of the bill. He's from the New Hampshire School Funding Fairness Project. He has for 2 minutes.
Thank you, Mr. Chair. Can all the members of the committee hear me all right?
Yes, go right ahead.
Wonderful. Well, Chairman Dolan, Representative Porter, members of the committee, thanks so much for the opportunity to speak with you this afternoon. For the record, my name is Jeff McLynch, and I'm the project director of the New Hampshire School Funding Fairness Project. We're a nonprofit organization that seeks to educate citizens and policymakers about the system New Hampshire uses to fund its public schools, to build awareness of the shortcomings of that system, and to advocate for changes in law that make that system more equitable for students and taxpayers alike. As House Bill 486 would make real progress in improving taxpayer equity, we strongly support this bill and urge the committee to recommend it as ought to pass. As members of this committee are aware, one can't discuss New Hampshire's tax system without talking about the property tax. It's far and away the largest tax collected in New Hampshire, generating close to $4 billion to support state and local public services in 2019. Yet that property tax is also an unfair tax, as it places a far greater responsibility on low and moderate income taxpayers than it does on more affluent ones. The latest data that we have from the Institute on Taxation and Economic Policy suggests that the poorest 20% of New Hampshire households, and those are households with incomes under $26,700, paid roughly 6.2% of their incomes in property taxes in 2018. In stark contrast, the wealthiest 1% of households, each of which had an income in excess of $514,000, paid an effective property tax rate of just 1.9%. Now, despite New Hampshire's heavy reliance on the property tax, and in turn that tax's heavy toll on the least well-off, the state does very little to mitigate the impact of the tax on those struggling to make ends meet. As Representative Fellows has already discussed, the state's principal approach to property tax relief, the low and moderate income homeowners property tax relief program that's the subject of this bill, has all but evaporated in recent years. And she provided very detailed information about that, so I don't want to belabor that point. And as she also discussed, the bill before you would seek to reverse that trend and to aid New Hampshire homeowners facing financial hardship, both by expanding the number of taxpayers who could take part and the value of the rebates that they would receive. In bolstering property tax relief, House Bill 486 is consistent with one of the key recommendations offered by the recent commission to study school funding. As members of this committee may know, that commission met for much of last year, despite the pandemic, and received hours of input from school finance officials, tax administrators, academic experts, and members of the public. They examined New Hampshire's school property tax system at length, and after doing so, they recommended that, among other changes, and I just want to quote from the report, the state should enhance taxpayer equity through property tax relief targeted to homeowners and renters through a low and moderate income property tax relief program. This program should include updated limits to income, home value, and net worth, and be satisfactorily funded by the state. And one final point I'd like to offer is that at the present time, the House of Representatives is actively considering changes in tax law intended to spur economic growth and to ease the difficult economic situations many families now face due to the pandemic. Any effort to use New Hampshire's tax system to achieve those ends should start with property tax relief efforts along the lines of House Bill 486. House Bill 486 would put money in the pockets of Granite Staters still coping with the economic consequences of the pandemic, and thus allow them to shop and spend at local businesses striving to remain open. For these reasons, I once again urge the committee to recommend House Bill 486 as ought to pass, and I look forward to working with the members of the committee to make New Hampshire's tax system more fair for everyone. I'd be happy to answer any questions you might have.
Porter, do you have a question?
Yes, I do, Mr. Chair. Thank you. And thank you, Mr. McLynch, for taking my question. Am I correct in saying that when a taxpayer applies for this rebate, it is not taken from the town's coffers in any way, nor does it impact the funding that school systems get? Am I correct?
That's absolutely correct. To, I believe, another rep's point earlier about whether cities and towns opt in, they don't. This is universally available for anybody with income below certain levels. It's available not just to elderly homeowners, but to younger ones as well, should their incomes be sufficiently low. And it doesn't in any way figure into the calculation of aid that those cities and towns receive for school funding. While the funds come out of the Education Trust Fund, that trust fund, as you know, is always made whole if needed by the general fund.
So increasing the limits so that people get higher rebates is not going to have an effect on the budget for the Hillsborough Deering school system or my local property taxes.
That's absolutely correct. And if I could expand on a sort of discussion that was offered earlier, while this is tied to the statewide property tax, that tax has over time played a smaller and smaller role in funding schools. And so there's every reason to increase this relief, because much of the job that tax was doing is now being pushed down onto localities. And so relief really does need to be expanded to make up for that.
Thank you.
All right, thank you. There are a couple of hands raised, but I was considering taking this to an immediate executive session vote. Does Representative Mangiapudi and Representative Fellows still have comments they want to make before I go into executive session?
Thank you. You want to go, Mr.?
I just wanted to clarify that the process to get the rebate is that the homeowner pays the tax bill to the town and then sends a form to Revenue Administration, and Revenue Administration sends them a check.
Thank you. And Representative Mangiapudi, do you want to make an additional comment?
Yeah, thank you, Mr. Chair. This is to either Representative Fellows, or I didn't quite get the name of NHS FFP person. My question is that property tax is collected in two parts, right? One is at the state level and one at the county level. So this is the state's portion of it that pays towards the education funding. So this clearly shows, or at least in my, pushing the responsibility and expense to the local and not providing that relief at the state level. Am I making sense?
No.
Yes, Representative Mangiapudi. If you look at a tax bill, there will be a line for the municipal tax for the town or the city tax. There will be one line for the state education property tax and another line for the county tax. And then sometimes there are different, like water districts or something on there also. So they're all separate They're all on the tax bill and you pay them all at once, but they're distinct amounts.
Okay, at this point, I'd like to conclude the hearing on this bill on 486, and I'd like to take it immediately into executive session. So I'm looking for a motion from Representative Tripp.
I move ought to pass on House Bill 486.
Is there a second?
Second.
Second from Representative McBride. Any discussion? Motion is ought to pass on House Bill 486. Mr. Clerk, would you take the roll?
Bill, ought to pass on HB 486. Representative Lamonti.
Yes.
Clerk votes yes. Representative Tripp.
Yes.
Representative Guthrie.
Yes.
Representative Lascelles.
Yes.
Representative McBride.
Yes.
Representative Melvin.
Yes.
Representative Lang.
Yes.
Representative Power.
Yes.
Representative Porter.
Yes.
Representative Tree-Levin.
Yes.
Representative Pimentel.
Yes.
Representative Majori.
Yes.
Representative Davis.
Yes.
Representative Mangaputi.
Yes.
Representative Van.
Yes.
Representative Clay.
Yes.
And Representative Gallagher.
Yes.
And then Representative Dolan.
Yes.
19-0.
19-0. Without objection, I'll place this on the consent calendar.
Mr. Chair, isn't this FN? Can you place an FN on consent calendar?
No, it has to go to finance first and then it can go on consent. Good catch. This goes to finance committee for second committee opinion.
Thought that was too late for that.
All right, next, that will conclude the executive session at this time. Next hearing is on HB 512, which is a bill relative to emergency housing assistance.
Mr. Chair, I have another procedural question.
Yes, what is your question?
Isn't it a little late for the second committee assignment? Didn't we have to do the second committee bills before last week's session?
I believe we did, but Representative Lang, can you help me on this?
Yeah, sure. So it's going to be a second committee bill, but because that's just note, it needs to go on regular consent calendar. It doesn't go to another.
Oh, it does. Okay. Is that cleared up?
Mr. Chair, I didn't hear it.
I didn't hear it.
It will not go to the finance committee, but it'll go on the regular calendar. Okay, so the next bill is House Bill 512, which has to do with emergency housing assistance. And we have, is it Casey Conley? Is that going to be the prime sponsor to introduce the bill?
Mr. Chair, is Casey Conley in the room?
He's not. He was here earlier.
I have been texting him and he's been anxious to speak. I don't see him on our list, and if he's not in the room, I would be happy to introduce the bill because I do see Mr. Elliot Berry is on the list ready to go. So if that's okay with you, I'd be happy to do that for you.
Please, go ahead.
So members of municipal and county government, my name is Jim Majori, representing the town of Northampton, Rockingham District 22. I thank you for your time and I'm happy to introduce House Bill 512 relative to emergency housing assistance. And Mr. Chair, I did get a note from Representative Connolly, who is sprinting down the hall.
Okay. We'll give him a couple of minutes to get in. No running in the hall.
If I text him that, he'll trip looking at the phone.
Well, both speakers are in support, so why don't we go to Elliot Berry, and we'll follow up with, Mr. Connolly just arrived. So, right up to the front of the room, please. We're looking for you to introduce the bill.
In my committee, Mr. Chairman, we've been facing the camera. I assume that's what you prefer.
Yeah, that's fine.
Okay, Mr. Chairman, I'm ready. You are ready for me to go.
Yes, please go ahead, right ahead.
Okay, Mr. Chairman, committee members, I'm Casey Conley, State Representative from Dover, representing Stratford County District 13. Here now to introduce HB 512. This bill would prohibit municipal welfare, or basically would prohibit cities and towns from establishing rules that require an inspection as a stipulation for dispersing emergency housing assistance funds. In New Hampshire, as the committee knows, state law requires municipalities to provide for their residents who are indigent. This is set up as sort of the last line of support for people who have exhausted other means of assistance. This bill would, or the law also requires municipalities to enact guidelines for providing that support. In some communities, one of these guidelines is the requirement that dwellings be inspected for code compliance prior to providing housing assistance. The purpose is reasonable. It's to ensure that this rental housing is safe and livable. But landlords are under no obligation to allow this inspection. So as you can imagine, it can lead to people who would qualify for assistance being evicted from their homes because the inspection is refused. And people who, essentially people would be evicted who might otherwise be, or who would otherwise be able to stay. The committee has heard a number of bills this term already, highlighting the seriousness of the state's affordable housing crisis, so I won't repeat that. But the challenge in finding suitable housing is more difficult after eviction. And this bill is intended to keep people who have homes in them during a time of severe housing shortage in our state. Finally, Mr. Chairman, I would acknowledge that this is, of course, a unique time in our state, in our country. There's unprecedented federal support for tenants. This money is making itself available in our state. This is a good thing. This bill is separate from that process. This is really intended to address an ongoing concern, not a concern that necessarily is tied to the COVID pandemic. So with that, I'm happy to take questions and I ask to support passage.
Okay, so questions for Representative Conley. We have Representative Davis with her hand up.
Yes, thank you, Mr. Chair, and thank you, Representative Conley, for taking my question. I was going to offer an amendment or a proposed amendment to this bill that would have added the word temporary before emergency housing assistance. But listening to your testimony, I'm thinking now that it may be more appropriate to say something about the fact that these are emergency housing funds that are being supplied, not in fact emergency housing. I mean, and I'm asking this question as the chair of the board of a large social services nonprofit here in the Upper Valley. We do a lot of housing assistance. And we have several different kinds of housing assistance programs. None of them actually provide physical housing. They provide funding for people to obtain physical housing. So I guess my question is, what exactly is the emergency housing assistance that this bill anticipates?
Representative, thank you. Let me try to answer that. So in the welfare office of a city or town will often step in as sort of the last with nowhere else to go. That's where you can attempt to find some assistance. And as I noted, and I was out of breath rushing up here, so forgive me, but the purpose is there's a hurdle in place in some communities that prevents that funding from being dispersed. So this is solely about cities and towns and the municipal welfare assistance. If I didn't answer that, or if I misunderstood your question, please let me know and I'll try again.
No, follow up, Mr. Chair?
Yes, please.
Thank you. Now, Representative Conley, that definitely does answer my question. And I'm thinking that to give this bill the best chance of success, do you think that it would be wise to specify that these are emergency assistance, housing emergency assistance funds, and not in fact physical places? Did you see the difference?
Representative, I did not catch that error in the bill. I appreciate you for pointing it out. And I trust I trust that you've identified something that needs addressing. So I would support that. That sounds fine.
Thank you.
Representative Porter?
Thank you, Mr. Chair, and thank you, Representative Conley. I'm a little confused too. If I'm understanding correctly, somebody is living in an apartment or a home and they experience hard times and they go to their town welfare office and ask for financial assistance to pay their rent. This bill would prevent then the town from saying, we have to inspect the premises first before we give you the money.
Precisely, and
Okay.
Okay.
Thank you.
Representative Mangiaputi?
Thank you, Mr. Chair. Thank you, Representative Conley, for taking my question. This bill does not differentiate between a renter or a homeowner? If I'm a homeowner, I can't afford to code-specific changes, but my tenant is unable to stay there. So it would help either way, correct?
Yeah, I presume it could help either way, if I'm understanding what you're saying.
That as a homeowner, I mean, the owner of that rental unit that's falling apart, but I can't fix it, but I could make sure that so the tenant cannot be kicked out because it's not code specific, because of my undue diligence, or I'm not able to fix it.
That scenario is a little bit different than what's envisioned as a remedy for this bill. Although if the property owner qualified under the existing terms of that particular town's welfare program, then presumably yes.
Thank you.
Next question from Representative Fleet.
Thank you, Mr. Chairman, and thank you, Representative Connolly, for taking my question. I think it kind of piggybacks on what Representative Stavas had asked, as well as Representative Porter. So I just want to clarify, this is emergency funds for a place that I currently live in but can't pay rent. It's not the same thing as if you had a fire within the apartment and we had to displace the residents there, and someone offered up housing. I guess what I'm saying is like what happened in Manchester when they tried to open up their police department, but they needed to have it inspected. They opened up emergency housing, but it couldn't get inspected in time. So this would not qualify for that. This would just be qualified for someone who's already in a place. Is that correct?
Yes. Again, so to use a scenario, if it's somebody approaches the municipality for welfare assistance, they meet the income requirements and all else. Everything is ready to move forward, but for this inspection, which the landlord is under no obligation to allow the inspection to take place. Under that scenario, the tenant could absolutely be evicted despite the availability of support that could not be utilized. Okay.
Next question.
Thank you.
Representative Davis.
I'm good, thanks.
Yes, Representative Lang.
Thank you, Representative Conley, for taking my question. How does this deal with any possible substandard housing that might be available? How does the town protect about giving funds for substandard housing? We're dealing with people that are kind of in crisis, and then we're going to put them in a bad situation potentially.
Yeah, thank you, Representative. That's definitely, we've thought that I and others I've worked with on this bill have really been torn on that question because it's absolutely a problem in our state and it's a concern. This really comes down to a value judgment that some housing is better than no housing in this kind of housing crisis time. And the fact that tenants under, any time, whether or not they're up against an eviction or not, could pursue a code complaint against their landlord or property owner.
Any question?
Yeah,
Representative Diamante.
yeah, I just have one concern on this. It's a place that bed bugs, rodents, something like that. I would hate to have that okay for somebody to go in there and live there without being inspected first.
Question?
Oh, I'm sorry. Would I?
Thank you, Representative. I share that concern. I would also reiterate that the conditions of the unit are what the tenant has been living in presumably for some time that has led up to this crisis. And with the dearth of options for people, the lack of affordable housing alternatives, again, it's a judgment that I'm putting out that others may not agree with, but that some housing is better than no housing. That's the question.
Okay, next speaker we have is in support of the bill, Mr. Elliot Berry from New Hampshire Legal Assistance.
Thank you, Mr. Chairman. Can you hear me okay?
Yes, you're doing fine. Go right ahead.
Thank you. My name is Elliot Berry. I'm the Director of Housing Justice at New Hampshire Legal Assistance. I've been representing low and moderate income tenants for 44 years. It's a strange position for me to be in. Throughout those 44 years, I have been doing everything I can to help low and moderate income people obtain and maintain decent, affordable housing. And in a normal housing market, I wouldn't support anything like this. But we're not in a normal housing market. The median income for a 2-bedroom apartment statewide is $1,413 a month. The vacancy rate statewide is 1.8%. So if you apply, you realize what a market like this causes for low and moderate income people in search of housing. I've had to take another look at this. Local welfare recipients are generally the poorest people in a municipality. The statute says you have to be poor and unable to support yourself. By far the biggest line item for most local welfare offices is rent, because there's nothing more important to relief and maintenance than is housing. These people who go to local welfare, who are the poorest in the municipality, generally live in poor housing because that's all they can afford. So what happens when they fall behind in rent? They go to the local welfare department, found eligible in some, and not all municipalities do this, but some do. They're eligible conditioned upon an inspection and passing the inspection. But many landlords don't cooperate with the inspection or won't make the repairs that are required. Therefore, the town doesn't assist, the tenant can't pay, the tenant gets evicted, and not only is the tenant poor and unable to pay those very high rents all over the place, but now he or she has an eviction on a record, making it even more unlikely that they can find any decent place to stay and the result is too often that they become homeless. Most inspections in most cities and towns are based on the fact that the tenant made a complaint. It's up to the tenant to complain, and I think it's totally consistent with New Hampshire values to let the tenant be the one to come make the complaint. And then if they do, of course, the Housing Code Department can do and order repairs, that are appropriate under the Housing Code. But shouldn't a tenant who applies for local welfare have the same choice of whether or not to complain as any other tenant? Municipalities under this bill can still respond to tenant complaints or neighbor complaints anytime. Or a city is free to adopt what they call a certificate of compliance program, where every few years, on a staggered basis, each rental unit is inspected and get a certificate of compliance if it meets code standards. Undoubtedly, the municipalities that do impose a requirement that there be an inspection prior to granting local welfare assistance is well intended, but it should not in practice become a punishment for a local welfare applicant who's seeking rental assistance. When the choice is substandard housing or no housing at all, regrettably, terribly regrettably, I think we have to choose some housing. And I urge your passage of the bill. Let me say, if I could, that in response, I think it was Representative Davis to indicate that we're talking about funds, not actual housing. I think if we added the phrase pursuant to RSA Chapter 165 to paragraph 2 of the bill, so it would read, no municipality shall require a housing code inspection as a condition of emergency housing assistance granted pursuant to RSA Chapter 165. Under RSA Chapter 165, all assistance is by voucher. It's a promise to pay from the city to the landlord. And I think that would take care of the ambiguity. But thank you for pointing that out.
Could you repeat that, please?
Sure. The language I would add to the very end of the sentence, the words granted pursuant to RSA Chapter 165.
165?
Yes.
Thank you very much.
Thank you.
Okay, Representative Mangiapudi.
Thank you, Mr. Chair. Thank you, Mr. Barry, for taking my question. This is at a point where the low income totally face, because of the housing shortage, in either eviction, which leads to homelessness, or providing the support at the most critical phase where we are trying to reduce the number of homelessness. Can I make that assumption?
You can, and you said it better than I did. Thank you.
Thank you.
Okay, our next speaker, Mr. Chair. Yes, I'm sorry, Representative Lyons.
Thank you for taking my question. Considering you're from legal assistance.
Correct.
What's the liability for the town if it puts it allows a citizen or a resident to sit in a building that potentially is unsafe? If something happens, is there any kind of liability that would result back on the town for not doing an inspection and confirming it's a safe building?
I've never seen a case like that. And in fact, the cities, in every city and town in New Hampshire today, as we speak, a number of households are living in homes that are seriously substandard.
My question was, the town sanctioning this by giving them funds to stay in an unsafe building, does it then assume any liability?
I don't think so. I've never seen it. And I should point out, I think this is helpful to know, the majority of municipalities do not do this, as far as I know. And again, I don't think I've never heard of a case where they've been found liable for providing assistance to places that don't meet code.
Thank you. Representative Mattieri, do we have any members of the public that have their hands raised that I can't see on my screen?
I do not see any other members of the public, Mr. Chair.
Okay.
Two members from our committee, though.
I see. Representative Mattieri, you had a third question?
No, sorry, I didn't put my hand down.
Okay, Representative, please.
Thank you, Mr. Chair. My question is that currently, if a unit is what I would consider substandard, and I have seen some of those, without the request of the tenant, the municipality cannot do anything. In other words, we can't force our way in or anything to that nature. Is that correct?
I believe there is a procedure to get an administrative warrant, but again, that is something that happens very, very rarely. The other thing that you should know, just to complete the picture though, is that when it gets to a situation where it really is a serious threat to the health and safety, either of the residents or of the general public, the municipalities, usually through the fire department, but also sometimes through the health department, can bring an action to actually they get cease and desist orders to move people out. And they do that not often, but when they do, that happens very quickly.
Thank you.
Okay, seeing no further hands up, I want to make a note that the blue, so-called blue sheet has a support of 91, with opposition of 3 for House Bill 512. Thank you. And that will conclude the.
Can you say that again, please, Mr. Chair? It was broken up.
Sorry, 91 support, opposed 3. So that concludes the hearing on 512. We're going to now move it right into the hearing for House Bill 545. This will be the last hearing of the day. Assuming that Representative LaFlamme is the sponsor.
Yes, and should be all set to speak, Mr. Chair.
Okay, please go right ahead, Representative, and tell us about the bill.
Thank you, Mr. Chair, and good afternoon to members of the committee and members of the public. I'm here to introduce House Bill 545, which is the exact same bill as Representative Moynihan had introduced last year as House Bill 1119. That bill was reported out of the committee as ought to pass 18-1. It was placed on the consent calendar and was passed by the House by a voice vote, and went to the Senate and got tabled as so many other bills were. During the testimony for House Bill 1119, it was supported by the New Hampshire Bankers Association, as well as the New Hampshire Association of Counties. Due to mergers and acquisitions, there are 4 banks remaining in New Hampshire north of Lancaster. Of the 4, only 1 bank is state chartered. In Coos County, the Register of Deeds, the payroll account, the nursing home the residents of the nursing home direct deposits are some of the banking business, some of the deposits that are in local banks that are not state chartered. These accounts, of course, all need to be transferred. And there are people on who can explain what that process is going to be, especially the nursing home residents, which the money is held in fiduciary trust by the county, as I understand. House Bill 445 gives New Hampshire counties and municipalities the flexibility that they need so they can utilize banking institutions that are local banks with brick and mortar presences in the towns, but are not chartered in New Hampshire. And that's the purpose of House Bill 545. And there are other people who are willing to testify today who have a lot more knowledge on the subject than I do, but I would be happy to answer any questions from the committee to the extent that I can give them an answer.
Any questions from the committee? Seeing none, let's go on to Katie Horgan, who's with the New Hampshire Association of Counties, that wants to testify in support of the.
Thank you, Chairman Dolan. Good afternoon to yourself and members of the committee. Again, my name is Kate Horgan. I'm the Executive Director of the New Hampshire Association of Counties, which represents all elected and appointed officials in New Hampshire's 10 counties. The New Hampshire Association would like to register its support for House Bill 545. As you've heard, this would allow New Hampshire counties to expand their banking opportunities to institutions that may not be chartered in New Hampshire, but are local banks. For example, Bangor Savings Bank in Colebrook was the original first Colebrook bank and has been in the same location since 1889, yet it is unable to be utilized by Coos County as a banking institution because it is not chartered in New Hampshire. This is an extremely important bill to our more rural and border counties that have to drive extended distances to complete county banking. While technological enhancements have increased some banking access, there are still some items, particularly our nursing homes, where we need to have cash on hand and transactions cannot be completed electronically. It would also allow us to seek out the best banking opportunities for our counties. We would ask for your support for House Bill 545, and I'm happy to take any questions.
Any questions from Ms. Horgan? Seeing none, let's move on to Carrie Cleve. Is that pronounced right? A member of the public speaking in support of the bill?
Yes.
Okay, please, you sound great on the transmission, so please go ahead and testify.
Okay. Good afternoon, Chairman Dolan and representatives. My name is Carrie Cleve, and I am the Finance Director for Coos County and the Treasurer for the Town of Columbia. I am support for HB 545. This is not an issue with our rural municipalities desiring to move our banking services to out-of-state banks. We are looking to continue banking with our longtime local banks that have merged with neighboring out-of-state banks. I am going to give you two examples. First Colebrook Bank was established in 1889 in Colebrook, and in more recent years expanded to southern New Hampshire markets in Amherst, Concord, and Portsmouth. In 2015, First Colebrook Bank changed its name to Granite Bank, and in 2018 merged with Bangor Savings Bank, a Maine chartered bank. Sewoogonock Bank was established in 1887 and had 2 branches in Coos County. In 2006, Passumpsic Bank, a Vermont chartered bank, merged with Sewoogonock Bank, and in 2008, Passumpsic Bank also merged with Lancaster National Bank. This is how Coos County's municipalities began banking with Vermont and Maine chartered banks that have a physical presence in New Hampshire. I'm looking forward to your support. Thank you.
Any questions from Ms. Cleve? Seeing none, next to speak is Mr. Timothy Felter from Newbury Bank. He's to speak in support of the bill.
Good afternoon.
Right.
Hello?
Go ahead, Mr. Felter.
Thank you. Thank you, Chairman Dolan and honorable members of the House Municipal and County Government Committee. I appreciate the opportunity to speak before you today. My name is Timothy Felter, and I'm the Senior Executive Vice President, Chief Financial Officer, and Treasurer of Newburyport Bank. We're a $1.2 billion bank located on the seacoast of New Hampshire and in northern Massachusetts. While the bank is 167 years old, half of our branches have been opened in New Hampshire in just the past 7 years. We have a branch in Dover, Exeter, Hampton, and 2 in Portsmouth. Over the 7 years, the bank has originated over $246 million of loans while taking in $138 million of deposits in New Hampshire. Our New Hampshire payroll in 2020 for 37 employees was over $2.7 million. My point in all these facts is strictly to point out that our commitment to the state of New Hampshire is as solid as any of the institutions that may be otherwise chartered out of states and other places, as well as in the state of New Hampshire. Our bank has been a good corporate citizen. During the last 7 years, we've made charitable contributions of almost $700,000 to New Hampshire not-for-profit organizations. And for example, the bank recently supported the mayor of the city of Portsmouth's initiative, the Clipper Strong Fund, during the COVID-19 pandemic. The bank has supported Families First, a full-service community health center located in Portsmouth, for the past 8 years. Our support of New Hampshire organizations is not limited to time and cash contributions. We've also supported the New Hampshire CDFA through the purchase of tax credits, with the purchase of over $121,000 of tax credits to benefit over 12 very worthy projects in the state of New Hampshire. I'm testifying here today with the expectation of leveling the playing field for our government banking division. Currently, New Hampshire laws require banks chartered in other states to post collateral for New Hampshire municipal deposits. Out-of-state banks which have national charters don't have that same requirement. And so what we're looking to do is to see that banks are treated fairly regardless of our charters.
Sorry, go.
When we started opened our government banking business in 2019, we learned that the playing field wasn't level, but we forged ahead anyways. And what we have done is make sure that the additional collateral requirements required by New Hampshire regulation are covered in our costs. And so it's accordingly, the rates that we pay to our New Hampshire municipalities are lower than what we pay in another state because of the collateral requirements. So in fact, it's not the bank that necessarily suffers from this requirement, but is the local municipalities, which could be earning more on their deposits, a higher interest rate. And so while the bill generally does ensure fairness for tax-paying businesses in New Hampshire, there are some aspects of the current version of the bill that fall short of its potential good to provide municipalities with access to more banking choices. Our bank is generally supportive of language in sections 1A through D. However, these sections need to be modified, in our opinion, to be fair to all banks, regardless of charter. Banks have played an important part in our country's response to COVID-19, and community banks in particular have been very supportive of local businesses, community support organizations, and individuals. We are committed to working with the legislature to ensure that New Hampshire municipalities have the same opportunity to get top quality banking services at a fair price. While we agree with the spirit of the bill, we believe more refinement of the language is necessary, particularly since it could have unintended consequences, which would ultimately do a disservice to New Hampshire municipalities. Thank you very much.
Thank you, Mr. Felter. Are there any questions from the committee? Yes, I don't see any. Any questions from the public that Representative Maggiore that you can see that I can't see on my screen?
Thank you, Mr. Chair. We do have Christy Merrill from the New Hampshire Bankers Association who would like to testify, but other than that, I do not see any questions.
Ms. Merrill, you have the floor. Please,
good afternoon. Can you all hear me okay?
Yes, please state where you're from and whether you support or oppose this bill.
Very good. My name is Christy Merrill. I'm president of the New Hampshire Bankers Association. We are not officially taking a position. Mr. Chairman, we also have our legal counsel, Rob Dietl, from the Gallagher, Callahan, and Gartrell law firm. Is it possible to have him join me?
Yes. Could you give us his name again so we can put it in the minutes?
Rob Dietl.
Spell the last name.
That is Dietel.
Okay, his position is he's an attorney?
Yes, he is legal counsel to the New Hampshire Bankers Association.
Okay, thank you. Go right ahead.
Good afternoon, committee. Can everybody hear me?
Oh, is this
This is Attorney Deedle.
Okay, go ahead, Mr. Dito.
I'll let Christie speak. I just wanted to make sure everybody could hear. Thank you.
Okay, Ms. Merrill, you're up.
Very good. Thank you so much, Mr. Chairman. As I said, I'm president of New Hampshire Bankers Association. We represent 37 state and federally chartered banks, which employ nearly 6,000 employees in New Hampshire. I just want to clarify that we were involved in the legislation last year, as was stated, but we did not have an official position. So we were very much involved in the dialogue and worked in the sponsor, but we weren't officially taking a position. And so Attorney Deedle is here today and he can help answer any legal questions as well. While we don't have an official position, we do come before the committee today to respectfully ask that this bill be amended to allow for a study committee. Turning House Bill 545 into a study committee will allow for a more thorough review and allow for input from various stakeholders to ensure the proposal creates a level playing field. I would like to say that we support we understand that municipalities want to have more banking options and we support that, but it is very complicated and we want to make sure that we get this legislation right. So as I mentioned, our membership consists of New Hampshire chartered banks, banks chartered in other states, and nationally chartered banks. Municipal deposits is a very complex issue and affects the members of our association in different ways depending on their charter. Under the current statutes, banks chartered in other states are limited in the types of municipal deposits they can accept, while New Hampshire chartered banks and nationally chartered banks with a physical presence don't have the same limitations. This proposal attempts to break down the barrier these statutes currently create, giving out-of-state charter banks greater access to municipal deposits. And you heard a little bit from Newburyport Bank about how that works. This bill is nearly identical to a proposal from last year, House Bill 1119. And as I said, we worked closely to the sponsor to come up with a solution that would create a level playing field for all banks and the different charters. But in the end, though, we feel the bill did not achieve that goal. And we asked the committee last year, as we did today, to make that bill a study committee. What we are trying to do today is make sure that the legislation does not harm out-of-state banks that currently hold municipal deposits. We also want to make sure that New Hampshire banks have comparable access to municipal deposits in other states, and that's a very tricky point. And it's also important that the municipalities that are seeking additional options are not negatively impacted by this legislation, and we understand that that is not the intent here. In order to accomplish this, we believe it's important to carefully work with the various stakeholders in order to strike the right balance. I do want to point out that in trying to come up with a workable solution last year, we did have conversations with the treasurer since they play a role in this, and that conversation occurred with former treasurer Bill Dwyer. We're unaware if any conversation like that has happened with our current treasurer, Monica Mezzapelli, but we believe that certainly would be appropriate. And we understand that the rationale behind this desire is to bring in language that originates from a constituent trying to address challenges in their banking needs. I understand that there was an interest in placing nursing home and prison residence funds in a bank that's chartered out of state. And we did hear a little bit about this. Attorney Deedle can speak to it, but after legal review and looking at the existing statutes, those funds are not considered to be publicly owned funds and should be able to be deposited into the county's bank of choice. But we understand the municipalities are looking for additional options, and we are supportive of that intent. Again, we don't have a position overall on the bill. We do want to get it right for banks that do business here. And that's why we're respectfully asking the committee to amend the bill into a study committee. That ends my testimony, and I will take any questions and we'll hand it over to Attorney Deedle as well.
Okay. Oh, I see two questions. Representative Porter, you had your hand up?
Thank you, Mr. Chair. This bill came through us last year. And I'm concerned that putting this into a study committee will further delay the relief that the counties and cities in the North Country have been experiencing. It's already been tabled in the Senate last time. And now if we put it into a study committee, that means that nothing will happen with it this year, and then it will be next year again before. That's 3 years to wait, and I'm concerned about that. Can you address that lag in time and how your association would recommend helping these communities?
Order. I would ask, I hear what you're saying, but it sounds like that's an executive committee discussion. I would ask if you could formulate your comment in the form of a question.
I did. I asked how they would recommend the communities proceed while they're waiting for this study committee to come up with a solution for them.
Okay, thank you.
Thank you for the question, Representative. Our understanding, as I mentioned, was that the county was looking to place prison resident funds and also nursing home to put their funds into an out-of-state bank. And our understanding is that they have the ability to do that. There may be other concerns that I'm not aware of. And like I said, my concern with this legislation as it's proposed, as it could have some unintended consequences. And you heard a little bit from Newburyport Bank, but in this legislation, I think what's most important are two goals. One is to make sure that the public funds are safe and sound. And second is to make sure that the funds are invested in communities where they're generated. And so that's what this legislation tries to do, but we don't think that the solution is quite right. And because this is such a big issue and that impacts so many people, we do want to make sure that we help those that need it, but we also want to make sure that we get it right. This is a statute. These are many statutes that haven't been changed in a long time. And so it very well may be time to take a broader look at this, but would just want to make sure that we try to anticipate any unintended consequences.
Christy, this is Rob Dietl. If I can add on specifically in response to Rep. Porter's question, I think it's important to note that while the public testimony has focused on county funds, that the bill is proposing amendments to, I believe, 9 different statutes that deal with state funds, county funds, town and city funds, school treasurer funds, and they impact more than just the specific issue that we believe has come to light in terms of funds being held with respect to county nursing facilities. They impact how funds are invested, deposited, trust funds, where capital reserve funds can be placed. To give you an example of the level of complexity here, in RSA 29.1, there are a number of restrictions on how counties specifically can deal with their deposits and investments. Currently, county treasurers can place those deposits in federally chartered banks, in New Hampshire banks, in out-of-state banks if they're collateralized, but investments are limited to federally chartered banks and New Hampshire banks. And I highlight these points because I think they really show that this is an area that has evolved over a number of years with various policy objectives under the various types of funds that are implicated. And it's not a simple solution from our perspective. And that's why we're asking in part for a study on this.
Hey, Representative Manchaputi.
Thank you, Mr. Chair. Having not been on this committee last year, this is my first time. And to understand if it passed last year, 18-1, and these concerns have showed up now in terms of trying to address the need for our county and residents of the North Country, specifically to get a relief. So I'm kind of puzzled as to how come this is such a big issue and it wasn't last week.
Thank you for the question. We were involved in the conversation last year, and we worked very closely with Representative Wayne Moynihan. Attorney Dietl can speak to some of the complications here. We argued unsuccessfully last year for a study committee. Ultimately, the committee wanted to move forward with the legislation. And as the sponsor said, it went to the Senate where it was placed on the table. So we did voice our concerns then as well. We had engaged in many conversations with Representative Moynihan, and the legislation went through various iterations before the committee passed it. And we were part of that. But it's just an evolving conversation. And I don't know, Attorney Dietel, is there anything you'd like to add?
What I will add is that the legislation, when it was advanced last year, and it has the same language in it this year, is dependent on the state treasurer playing a role in accepting opinions of council as to reciprocity. And we had some detailed conversations with previous state treasurer Dwyer. I'm not sure if, I know on the Bankers Association side, I don't believe those conversations have occurred. I don't know to what extent the sponsor has had a chance to connect with the treasurer. But I think that's an important point to hear from the treasurer as well in terms of whether this structure is still an acceptable structure.
Okay, Representative Davis.
Thank you, Mr. Chair. And I'm going to ignore the advice about never ask a question you don't know the answer to, because I truly don't know the answer to this question. But can one of the banking experts who testifying today tell me where Bar Harbor Bank is chartered?
Sure, Representative. This is Christy Merrill. I can try to answer that. They are chartered in Maine, my understanding.
Do business in New Hampshire, correct?
Correct.
So how is that different?
I'm not quite sure I understand your question. If you're asking why is Bar Harbor Bank treated differently, I think what it really comes down to, and where we struggled, is the notion of reciprocity. So, you know, if we take the states immediately around us in Maine, in Vermont, Attorney Dietel will tell you that the laws there are reasonably comparable. So a New Hampshire chartered bank that does business over the border there, they would be able to hold municipal deposits. There are some differences in the state of Massachusetts, which make it a little bit different. And so part of the challenge we have with this legislation is, you know, we originally went to the banking department because we thought they would be a logical arbiter to decide what is a reciprocal treatment. And we think that's very important to make sure that all of the banks have an equal playing field. And, you know, as the banking commissioner pointed out, these statutes are not located in the banking department statutes. They're scattered among the many statutes that have been referenced earlier. And so he did not feel that it was appropriate for the banking department to really be the arbiter. And so that's where we ended up with the treasurer's office. And so having, you know, an attestation, having legal counsel do an opinion and submitting that attestation that they swear under oath that it is in fact reciprocal. And you've heard Newburyport banks talk about how they have concerns about that. That was a solution that was put forward. We're not sure if that's the right solution or not. But again, we're trying to really get at that issue of reciprocity, which is really important to make sure that each of the states are playing in a similar manner and treated the same way.
Follow up, Mr. Chair?
Yes, go ahead.
I am thoroughly confused now. My question had to do with Bar Harbor Bank, which up until a few years ago was called Lake Sunapee Bank. So what is the difference between, is it a difference between we like Massachusetts less than we like Maine? I just don't understand what the objection is and why the objection wasn't raised when Bar Harbor Bank became Lake Sunapee Bank.
The other way around.
Sorry?
Chair Lascelles had a comment.
Yes, wasn't it the other way around? Sunapee became Bar Harbor?
I'm not sure.
That is correct, Representative. I think that's a similar situation. I don't know whether or not there was complaints mentioned at that time, but obviously in the banking industry, it's a trend here in New Hampshire with a lot of mergers and acquisitions, and that's a trend nationally. We know that's a concern, and as I stated originally, we support the municipalities wanting to have additional banking options, but we just want to make sure that we get all of these laws correct in doing so.
Okay, thank you. Seeing no additional questions. Do I see no additional hands up? Representative Maggiore, are there hands that I can't see that you might be able to see?
I do not see any additional hands up from panelists or from any of the members of the public or attendees, Mr. Chair.
Okay, the public hearing on House Bill 545 is complete. All right, we're going to go immediately into executive session. So I would ask those members of the committee to pay attention to the bills that I bring up, and we'll all have opportunity to discuss them.
Mr. Chair, is
Yeah.
it possible to get a list right now of the bills that we're going to be execing now so that I can start getting my papers out?
Yes. $439.
Excuse me, say it again.
439.
439.
463.
463.
467. 512. 545. 262. And 284.
Thank you, sir.
Okay, so for House Bill 439, I'll look for a motion from Representative McBride.
Thank you, Mr. Chairman. I would move that OTP.
And motion's been made to OTP House Bill 439. Is there a second?
Mr. Chairman, I second OTP on 439.
Okay, discussion. Any discussion on the committee on 439? Remember what that bill was? Okay.
Could you remind us, please?
Hand up, Representative Gallagher.
Yes, could you remind us, please, what that bill was?
This was the bill about restricting the amount of authority that local governments had. I think the example that was mostly discussed was around the pandemic issues that come up. Representative Maggiore.
Thank you, Mr. Chair. I'm going to be voting, I'm not going to be voting in favor of the ought to pass motion, and my concerns are numerous about this, but I will limit it to if in the Constitution itself the term general good is not defined, and we look here at well-being as the term which seems to be giving the sponsors the most grief, then I see no reason to take that language out. We understand from the Constitution a general idea of what the general good is, and I think we should leave it to the local municipalities to have the flexibility to decide what is in what well-being means to their community. Thank you.
Thank you. Representative Klee, your comment?
Thank you, Mr. Chair. I also will be voting against ought to pass, and I'll try to limit my comment. I do have an issue with the fact that it would mean that we would have to bring the body together in order to come up with a decision. And in the case of an emergency, this could be quite an undertaking. Also, in light of the fact that we don't have enough, I guess it was brought up about the zoning laws, et cetera, et cetera. So are we going to have to, each time we want to make any changes to that, have to come to the board? And I just think that there's too many pitfalls in it.
Representative Treleaven.
Thank you, Mr. Chair. My comment echoes both Representative Klee's and Representative Maggiore, especially the term well-being. I think it's there for a reason. I don't think it's a frivolous term, as some of the folks who testified before us. I think it's a salient term in regards to the health and well-being of a town, a municipality, in an unincorporated space. And the people who live in those spaces can make that judgment call on the well-being. The well-being of Dover might be very different than the well-being of Nashua, yet they are both well-being. And I will be voting no on this. No on this.
Thank you. Representative Mangiapudi?
Thank you, Mr. Chair. I will be voting no on this to pass for a couple of reasons. One is the fact that on one hand, we are trying to push fiscal responsibility to the local control. And on the same token, we're going to tie the hands of the local government to make emergency decisions or ordinances to safeguard the well-being of their community. Just like my colleagues have expressed, pandemic is a good example where Nashua did the right thing. I feel safe, my constituents feel safe, that was needed. And this will be taken away if this bill passes. For that reason, I'll be voting no.
Representative Porter?
Thank you, Mr. Chair. It was commented during the testimony that the government needs to be responsive to the citizens and that the local government shouldn't be passing ordinances that the citizens don't want. But it's the citizens of the community that elect their representatives to either the city council or the select board or whatever. And they elect those people, especially in a city, to be representative of them and make decisions for them that the 10,000 people in the city can't get together and make for themselves. To take away the local authority to make ordinances takes away the voice of the people who are elected to represent the people. So I feel that it's contradictory in nature and would be detrimental to local control.
Thank you. Representative Davis?
I simply want to echo what Representative Porter just said. That was exactly what I was going to say.
Okay, Representative Pimentel?
Thank you, Mr. Chairman. Yes, this bill is quite onerous to the running of the local government. Selectmen and city council are elected by the people to make regulations which are to the benefit of that community. And this puts too many roadblocks in the path of smooth running government. And it actually puts roadblocks in the legislature for, we would just be bogged down with so much frivolous legislation, which is better off done at the local level.
Thank you. We have a motion, OTP, and it's a second. Clerk, please call the roll.
Okay, OTP on HB 439. Yes. Clerk votes yes. Representative Tripp?
Yes.
Representative Guthrie?
Yes.
Representative Salas?
Yes.
Representative McBride?
Yes.
Representative Melvin?
Yes.
Representative Lang?
Yes.
Representative Power?
Yes.
Representative Porter?
No.
Representative Trelevin?
No.
Representative Pimentel?
No.
Representative Majority?
No.
Representative Davis?
No.
Representative Mangiapudi?
No.
Representative Van?
No.
Representative Clee?
No.
Representative Gallagher?
No.
And Chairman Dolan?
Yes.
You each have it 10 to 9.
Thank you. Next bill to.
Mr. Chairman?
Yes.
Mr. Chair, there will be a minority report. I'm not sure who will be writing it.
You're gonna write the minority report, Representative Porter, is that what you said?
No, somebody will. I'm not sure who, but there will be one.
Okay, please send that to me for approval when it's written.
Yes.
And Representative McBride, you're gonna write the majority report?
Yes, Mr. Chairman.
Bill is Bill 467 to consider. This was the issue with the open space funding and so forth.
Mr. Chairman?
Representative McBride, you had a motion?
Yes, sir. I would move ITL for 63.
Is there a second?
I'll second.
Representative Piedmont, second. Discussion.
Or 467. I guess I misheard.
Yes, we're discussing House Bill 467, and there's a motion ITL. Representative Gallagher has his hand up.
I am wondering, or I'd like to make a motion to table discussion on this bill until the sponsors indicated willingness to work on amending the language to make it more effective and easier to pass. And I would like to table discussion until they have had a chance to do that.
Okay, that motion is in order. Is there a second?
Second.
Motion been made second. Please take the roll on the table motion.
Yeah, I just set up. Table motion on 467. Representative Piedmont. No. Cliff says no. Representative Tripp.
No.
Representative Guthrie.
No.
Representative Lascelles.
No.
Representative McBride.
No.
Representative Melvin.
No.
Representative Lang.
No.
Representative Power.
No.
Representative Porter.
No.
Representative Tree 11.
Yes.
Representative Piedmont. Pimentel.
Pimentel.
No.
Representative Majority.
Yes.
Representative Davis.
No.
Representative Mangapudi.
Yes.
Representative Mann.
No.
Representative Clee.
No.
Representative Gallagher.
Yes.
And Chairman Dolan.
No.
It's 14-6.
14-6, the motion fails to table. We're back to the motion of ITL with the second. Seeing no further discussion, let's take a roll call.
Sorry.
13-6 was the table.
It's 14-5.
The motion, the vote is now to ITL.
Yes. Clerk votes yes. Representative Tripp.
Yes.
Representative Guthrie.
Yes.
Representative Lascelles.
Yes.
Representative McBride.
Yes.
Representative Melvin.
Yes.
Representative Lang.
Yes.
Representative Power.
Yes.
Representative Porter,
Yes.
Representative Trail 11,
Yes.
Representative Pimentel,
Yes.
Representative Majori,
Yes.
Representative Davis,
Yes.
Representative Mangapudi,
No.
Representative Van,
Yes.
Representative Klee,
Yes.
Representative Gallagher,
No.
and Chairman Dolan.
Yes.
Mr. Chair,
Wait a second. We're still in the voting.
17-3.
Yeah.
I know. 17
17 to 2.
17 to 2. Yeah.
The vote is 17 to 2. And Representative Porter, you had a question?
yes, Mr. Chair, I believe the vote to table was 14-5, not 13-6, as was reported, at least according to my count.
We'll double check that.
Thank you.
And I believe Representative Lang has to,
Yes, Mr. Chair, I'll be back in a few minutes. I need to run over to Leggy Acton to present a bill.
okay, thank you. Thank you for being here. Appreciate it. Next bill that we're going to take up is House Bill 463, which was the selectmen appointing the town clerk. That rings a bell?
Yep.
That, this morning.
Mr. Chairman? Oh, 463. Mr. Chairman?
So I'd like to look to Representative McBride for a motion.
Mr. Chairman, I would move ITL.
Motion's been made by ITL. Is there a second?
Yes, a second.
Second by Diane Power, Representative Power. Is there discussion on 463 before we vote? Don't see any discussion.
Representative Trelevin has her hand up.
I do.
Oh, yes, I see it now. Representative Trelevin, please.
Thank you, Mr. Chair. I had my real hand up and I couldn't coordinate myself to get the other hand up. I'm conflicted about this bill. And I'm conflicted because the town of Gorham has been thoughtful and done its work in trying to think ahead how things might work for them. And the Town Clerks Association person, although he was very persuasive, he's in favor of the way most people do it and town clerks do it. And he's not necessarily, sort of as I said before, got the well-being of Gorham in mind. He may have the well-being of town clerks in mind. And he was very, I think, a little presumptuous when he said, well, someone will run, don't worry, someone will run. Well, not necessarily someone will run. And I'm loath to say no to a town that's trying to find a proactive solution to what they consider a problem. The one thing that I might hope that they heard from the testimony is that they could split those two positions, and it might be easier for two people to run than one person to run for two jobs. And again, I'm still conflicted. That's my only commentary. I'll listen to others. Thank you.
Yes, Representative Guthrie.
Yeah, just if I may, I only can go by my own experience, but I think, as I said, in Hampstead, we had a vacancy, was in between the elections, and we appointed somebody, and they subsequently ran, and has been a very successful town clerk after being trained. She's been with us probably 12, 13 years. And so I don't think Gorham has to worry too much about a process to get a town clerk. They'll get somebody, I know it's just to say somebody will run, but there is somebody out there if you shake the trees. And I don't think they have anything to fear, and I don't think this solves their problem anyway. I think they still have to get somebody who's qualified. They have to get somebody to do the job, whether it's by appointment or election. They have either vehicle, and right now they have election. I just don't think we should make an exception, and I think they can work around this by talking to the town clerk, tax collectors that are on board now, and make sure that they resign in between the election. Then the town fathers, the town selectmen can have some input and go out and shake the trees and get somebody to run.
Yeah, this is a comment from the chair. I think one of the things that we heard was, that was just referenced was that, gee, they won't be able to find somebody who's going to sign up and get themselves on the ballot. Well, in cases like that, I know in my town, it's not uncommon to have nobody running for certain elected positions, and we end up having a write-in campaign for somebody, and whoever gets the most write-ins wins. So you don't actually have to have someone sign up for the election and they campaign for it, which it sounds like what I was hearing, if I read between the lines, is that certain people don't want to go through the campaign and get signs and all that stuff, but it certainly won't stop the community from filling the position through a write-in campaign. Representative Pimentel, you had a comment?
Thank you, Mr. Chairman. Yeah, I mean, I'm conflicted about this bill. I understand the sentiment of the bill completely as a former selectman. And unfortunately, this is a kind of a bill that really needs to go to a committee and really delve into it and try to work out something that'll work for all towns, the big towns, the little towns. Yeah, I'd love to vote for Gorham, but I just don't believe in just carving out a little thing for one town. I think we need a bigger bill to take care of it for all of New Hampshire.
Thank you. Before we take a vote, let me go back a little too fast here on House Bill 467 that just was voted to ITL by 17-2. I'm going to ask Representative McBride to write the majority report. And
Yes, sir.
of the
No
two
problem.
voted, do I have a volunteer on one of those two to write the minority report?
As one of the minorities, I don't see any reason to write a minority report.
Yeah, I don't see a reason to write a minority report either.
Well, we have to have one. So let me ask.
We don't need to have a minority report, only a majority report, especially on a bill this close. At least in the past, if you noticed in the calendar that we just voted on Thursday, there were a number of bills who had no minority reports.
I'll double check on that, but
thanks.
I hope.
Yeah, that's my recollection too.
So we're back with House Bill 463. There's been a motion to ITL in a second. Is there any additional comments before we take a vote? All right, seeing none, ask the clerk to call the roll.
Okay, Representative Piemonte? Yes. Clerk votes yes. Representative Tripp?
Yes.
Representative Guthrie?
Yes.
Representative Lascelles?
Yes.
Representative McBride?
Yes.
Representative Melvin?
Yes.
Representative Lang. Representative Power,
Yes.
Representative Porter,
Yes.
Representative Trelevin,
Reluctantly, yes.
Representative Penatelli, Penatelli,
Yes.
Representative Majority,
Yes.
Yeah, jury.
Representative Davis, Representative Davis,
My apologies. Yes.
Representative Mangaputi,
Yes.
Representative Van,
Yes.
Representative Klee,
Yes.
Representative Gallagher,
Yes.
and Chairman Dolan.
Yes.
18-0.
All right, 18-0. I'm going to ask the Representative McBride to write the committee report. There is no minority report required and without objection.
Yep, nope, I'll take care of it.
Representative McBride. Complete all those reports, minority and majority, have to be sent to me first. I have to approve them, and I'll send them on to Representative McDonald and our
Mr. Chair,
yeah.
can HB 467, no, 463 go on consent calendar? It's 18-0 with no FN.
Yes, that will go on consent. Okay, the next bill that we're going to consider is HD 512. That was the one about the code issues with assigning emergency housing.
Mr. Chair, Representative Davis had mentioned wanting to get an amendment maybe for this. Can you, Laurel, you still want to do this?
I've actually sent the proposed amendment to OLS and they're working on it.
Thank you.
Sorry, I didn't hear you.
All right.
You went to OLS and then I didn't hear anything after that.
They are working on the amendment.
Is there a recommendation that we maybe exec this on Wednesday if we and give ourselves a couple of days to get that amendment in order?
That would be good.
If we have consensus on that, I will move on from 512 and we'll exec that. I'll plan to exec that on Wednesday.
Mr. Chair, my husband just walked in from his back from work. Just want to let you know.
Thank you. All right, our next bill to an executive session will be House Bill 545. It's the one we just heard about on banks. Look to Representative Piamonte for a motion.
Make a motion on to pass on House Bill 545.
Representative McBride,
Second.
motion's been made and seconded. Is there any discussion on that bill before we take a vote?
So, since it's been a long time waiting for some relief up north, I think that you deserve a break. Last time they got shortchanged, tabled in the Senate.
That bill, as you remember, bill number 1119 last year passed 18-1 on the committee. In this particular bill, on the blue sheet, we had 18 support, 0 opposed, and 2 neutral. Just for reference. Is there any comment before we take a vote? Yes, Representative. Is it Matthew?
Yes, thank you, Mr. Chair. I just wanted to emphasize that I grabbed, I guess one of the benefits of working from home is access to records. And I grabbed the bill from when we first saw it, the original bill and the amended bill. And if anybody has any concerns about what we heard from the businesses, from the Banking Association, it seems all of their concerns, or I hope, I don't want to argue with an attorney, as I am not one and would lose that battle every day and twice on Sunday. But it seems that all of their concerns were addressed in the amendment, according to all of my notes. And the bill that we have in front of us, 512, is that amended bill. So I just wanted to pass that along to the members. Thank you.
Correction, I believe you meant 545, not 512.
545, I'm sorry. You're right.
Okay, just want to make sure as this is going out live, people are writing notes down to get the right. So since there seems to be no further discussion, I'll ask the clerk to take a roll on OTP on House Bill 545.
Okay, Representative Piemonte.
Yes.
Clerk votes yes. Representative Tripp,
Yes.
Representative Guthrie,
Yes.
Representative Gonzalez,
Yes.
Representative McBride,
Yes.
Representative Melvin,
Yes.
Representative Lang, Representative Power,
Yes.
Representative Porter,
Yes.
Representative Trelevin,
Yes.
Representative Pimentel,
Yes.
Representative Majori,
Yes.
Representative Davis,
Yes.
Representative Magafuni,
Yes.
Representative Fan,
Yes.
Representative
I have carpet.
Yes.
Representative Gallagher,
Yes.
and Mr. Chairman,
Yes.
18-0.
18-0. Unless there's an objection, I will put that on the consent calendar. I'll ask Piemonte to write the committee report. Okay, the next bill we're going to consider in executive session is House Bill 262. If you remember, that was the bill brought forth by Representative Yocella that was changing lot sizes in some cases to minimum size 1 acre across the state.
Mr. Chair, I think that's 284 you're discussing. Merged lots is 284.
You look at
Yeah.
I think 262 is the one requiring RSAs be put on
Right, the bylaws bill, that all the bylaws refer to an RSA.
Right. Yes. Yes, thank you. This is managing this committee is takes a village.
You should write a book.
I should. Let's see.
And Mr. Chair, we do have an amendment on that bill. Am I correct?
262.
Yes, sir.
We have one, do we?
I have 0456H. 2021-0456H, amendment to HB 262.
So,
Can you convey to us who are in the dark as to what that amendment is?
I don't think I have that.
I can read it, and if I can find it, I can email it, but
Yeah. Is it a long amendment?
it is not. It begins on line 9, and it says, it is amending the language that was already in bold, and it now says, every bylaw and ordinance enacted or amended after the effective date of this introductory paragraph shall state the RSA section that enables such bylaw or ordinance. However, if the applicable RSA section is subsequently renumbered, no change shall be required in such bylaw or ordinance as suddenly has now appeared brightly in front of all of us. Thank you to
Christina.
Christina.
Representative Maggiore, could you read out the amendment number as well for the, especially for me and the clerk?
Happy to do so. It is 2021-0456H.
Thank you.
You're welcome.
All right, so I would ask,
I move OTP on the,
no.
no?
I think,
Discuss the amendment.
I think I'm going to take a motion to ITL the bill from,
Don't you have to do the amendment first?
only the amendment only applies if it's an OTP.
Thank you.
I move ITL on House Bill 212. 262.
Is there a second from Representative McBride?
Second.
And the motion's been made and seconded to ITL. If the motion to ITL fails, then we'll take up the amendment in a different motion.
Thank you, Mr. Chair.
Is there any discussion on the ITL motion on 262? Seeing none, I'll ask the clerk to call the roll.
Okay, ITL on 262. Representative Tremonti.
Yes.
Clerk votes yes. Representative Tripp,
Yes.
Representative Guthrie,
Yes.
Representative Lascelles,
Yes.
Representative McBride,
Yes.
Representative Melvin,
Yes.
Representative Lang, Representative Power,
Yes.
Representative Porter.
Yes. Oh, excuse me. Yes.
Yeah, thank you. Representative Tree 11.
Yes, Mr. Clerk.
Thank you, ma'am. Representative Pimentel,
Motion to ITL, that would be a yes.
Representative Majori,
Yes.
Representative Davis,
Yes.
I'm sorry, Representative, hear you.
Yes.
Thank you, ma'am. Representative Mangaputi,
Yes.
Representative Van,
Yes.
Representative Klee,
Yes.
Representative Gallagher,
Yes.
and Chairman Dolan.
Yes.
18-0. ITL passes.
Okay, without any objection, I'll place that on consent. 18-0. And I ask you to write the committee report. Representative Lascelles will write the committee report. Thank you. The next bill we're going to discuss is House Bill 284, which is the one that I was erroneously spoken about before. This is the one about the changing the acreage down to minimum lot size. This was Representative McKellar's bill.
I think that's a different bill. This is about involuntarily merged lots. I think we already voted on the minimum lot size one.
My notes, yes.
This is Rep. McBeef's bill, not Representative Yokella's.
Right.
132. Right.
HB 284.
That's right. 284 was the one that had the extended the date additional 2 years to get it done.
Yes.
There was some discussion about, I know NHMA opposed that. They said they had long enough. And there was some other discussion about that maybe there should be any sunset date. So it was kind of a wide thought process around that. So I'd like to look to Representative Lascelles for a motion.
Mr. Chairman, I move we retain House Bill 284.
And is there a second?
Second.
Representative Howard seconds that. Is there other discussions on the motion to retain?
Mr. Chair, I would like to hear why someone wants to retain this bill. I'd be curious.
I just think that it needs more work, that it's not ready to vote either up or down.
Let me also say that there seemed to be a wide, there wasn't a lot of consensus around, yeah, we should do this, or maybe we should adjust it a little bit. It was wide disagreement between no extension to a 2-year extension to a 10-year extension. And so it looks to me like it needs to, that type of discussion seems to support. Any other discussion on the motion to retain?
Yes. Representative, yes, Mr. Chair.
Yes, please go ahead.
Thank you. I'd like to ask, again, I don't know that Representative Porter's question was answered. Why would we retain this bill to do more work on it? All it does is extend a practice that's already in place. So it supports a practice that landowners have been using and cities and towns have been satisfied with, and this extends it for 2 years. Why would we stop it? Why would we not allow this to continue to happen?
I think the reason or rationale is, one of the rationales is that we're not close to consensus on this. Representative, sure,
I was going to say that it seems silly to only do it for 2 years. I would suggest that we extend it another 10 years or indefinitely extend it.
Well, I'd be in favor of that, yet I don't know if that we're at a point where we can amend this bill right now without bringing in a new one. I'll be quiet.
Representative Mangiore.
Concur with what I just heard, because it's what I was going to say. It seems like an amendment to this could be done under the terms I just heard, 10 years or indefinitely, or we just kill it. But retaining the bill, I think we could do the work that would be done in that time frame with an amendment.
Okay, Representative Porter.
Yes, Mr. Chair, I was going to agree with what Representative Maggiore just said. If we can just make an amendment, we might have to hold until Wednesday to exec it, but if we retain it, we're just going to make an amendment to extend it. I mean, there might be other discussion that was had that I'm not familiar with, but right now what I'm hearing is we think it's a good idea, but it's not long enough. So we want to fix it, make it longer or make it indefinite. And then, if that's the issue, then an amendment could be done.
What do you all, those of you who want to amend it, what do you think you want to amend it to?
I'd amend it to 10 years or in perpetuity, personally.
We have consensus around that. What I don't want to go through is go through an OLS amendment and then just kill it on Wednesday. I want to make sure we have some type of consensus given the calendar that we're facing. Representative Klee, what are your thoughts?
Unmute, Trish.
I'm sorry. I agree with my colleagues. I think I have no problems with 10 years or in perpetuity. I think to retain this, to only basically do an amendment later on in the fall, just or next year, seems like better use of our time. And I would just recommend an amendment, and I'm okay with 10 or forever.
Representative Mangiapudi.
I will go with 10
Okay.
and make it simple.
Was that me?
Yes.
I'd like to recommend in perpetuity. I don't see any reason why we should ever stop the separation of involuntarily merged lots. I don't see that there's anything in it for us, and a lot of grief for other people. So my recommendation is an amendment saying that involuntarily merged lots can be unmerged at the landowner's request in perpetuity.
So is there consensus across the committee for perpetuity? If there is, we look for a volunteer to run that amendment to OLS, and we'll come back and we can hopefully get a unanimous vote on that. Who would like to volunteer to work with OLS on that amendment?
Representative Van might like to do it.
Representative Van may do it. I will write an amendment and get it to OLS later this afternoon.
All right, then let's plan on accepting that bill on Wednesday with an amendment. That sounds good to everybody?
Sounds good to me.
If we end up with a 10-9 vote, we're going to get some hate mail from OLS.
If it makes you feel any better, Mr. Chair, we were pretty unanimous that we wanted to pass the bill. We saw no reason to kill that bill. So, and the discussion we had was all about making it perpetual. So
thank you.
On our side, we're okay. I don't know how you are on your side, but.
Okay. The last bill I want to talk about is House Bill 512. That will be our last action today. And that's one that
the emergency one.
Emergency housing assistance.
I thought we already talked about that.
Yeah, I thought we were, as Representative Stiles had sent out an amendment for that, and we were waiting for 333 to exact it.
That's the one that I have a note here that Representative Davis was going to work that amendment.
I believe I said that a few minutes ago, Mr. Chair.
Okay, got it. All right, we'll plan on that on Wednesday as well. Another one that I'm going to wait till Wednesday on is House Bill 431. You heard this morning about the elected animal control officer. I just think that that one is of we got some very interesting testimony, and I just thought we needed more time to think about it. So we'll accept that one on Wednesday. Okay. That's it.
That it?
Let me alert you to one other thing.
Mr. Chair, my husband is now in the office with me. If you see a stranger walking around, that's who it is.
Okay, on Wednesday, we are scheduled to meet at 9 o'clock. But next Monday, let's not forget it. It's going to sneak up on you. It's 8:30 our start time next Monday, the 8th. So put that in your calendars. But on the 3rd, we'll be hearing some bills to start with. It's going to be a little odd that from 9 to 10:30, we have 3 budget bills to hear that the sponsor is working to combine all 3 of those into one bill. And that's why it's written out the way it is. So we try to be a little more efficient, especially when we get to the general session. We'll have, the plan would be to hopefully have 1 bill come out of that, and 2 of them would be ITL, so we'll reduce it from 3 to 1. We'll see. It may not happen, but that's what the thought is at this point, to try to make ourselves a little more efficient when we get to the floor. Representative Van, your hand is up. You have another comment?
No, sorry, I just failed to put it down.
Okay, that's fine. All right, thank you very much. I'm going to conclude the executive session at this point, and I look forward to seeing you all on Wednesday morning.
Mr. Chairman?
Yes.
Do you know where we will be meeting on Wednesday?
I believe it's here.
Are we finished, Mr. Chair? Are we adjourned?
Thank you very much.